morning.
No, we're not ready yet.
You're not ready yet?
Now we're
Advise
live.
me when you're ready.
Yes, sir. Check on the phone.
Yes.
Yes, sir, you're ready.
Ready now?
Yes, sir.
Good morning. I'd like to call the Code Enforcement Special Magistrate hearing.
Can't hear you. Cannot hear you.
Good morning. Do you hear me now?
Yes, sir.
All right, good. Good morning. I'd like to call the Code Enforcement Special Magistrate hearing for Wednesday, October 20, 2021, the Town of Pembroke Park to order. Roll call, please. Who is present? Raphael Special Magistrate. Proceed. Who else?
Sorry about that.
Chief Code Enforcement Officer Jocelyn Ramirez.
Code Enforcement Officer Teresa Malcolm.
Miguel Nunez, building official.
Thank you. I'm going to provide a brief opening statement to you so you understand these proceedings. Thank you and welcome. Please turn off your cell phones and there can be no interruption to the proceedings by cell calls and the like. No weapons are allowed in chambers or anywhere within the facilities. In all matters before us today, we ask that everyone show mutual respect and courtesy for one another. And okay, all right, so that's it. Okay, thank you. And listen quietly to each person speaking. Anyone refrain from any clapping, heckling, or verbal outbursts. Hearings are conducted by the special magistrate, purposes of which to give the alleged violators the opportunity to contest a decision of code enforcement, which resulted in the issuance of a violation notice. The hearings are conducted in a quasi-judicial manner, which means that I act much like a judge in a court. I hear cases presented. I hear contradictory arguments presented by the alleged violators. The hearings are open to the public. All persons who testify must be placed under oath. The hearings are not conducted in accordance with the formal rules relating to evidence and witnesses. Any relevant evidence will be admitted if it's to be competent and reliable. All documentary evidence will be submitted for placement in the hearing file. No documentary evidence is considered unless the alleged violator or the code enforcement officer submits a copy for the hearing file. All exhibits in the hearing file that are introduced, such as notices of violation, photographs, and so forth, are entered into the record and will be accepted unless there's an objection. If there's an objection, I will rule on it. Each party has a right to call and examine witnesses, to introduce exhibits, to cross-examine opposing witnesses on any matter relevant to the issues, though the matter was not covered in direct examination. The responsibility of the special master or magistrate is to find whether the alleged violation occurred or not. If so, whether the person or persons named in the violation notice can be held responsible for the violation. I can also modify the decision of the code enforcement officer as to the time for correction contained in the violation notice, even though that time is rebuttably presumed to be reasonable. I have the order to assess the payment of civil penalties, to issue orders having the force of law, to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs, which are $100 flat for each case. In order to make a finding upholding the code enforcement officer's decision, I must find that there is substantial competent evidence that the named violator was responsible for a violation of the relevant sections of the code as charged. If I affirm the decision, the order will specify the amount of the civil penalty, the administrative costs of the hearing, which are $100, the date by which the violation must be corrected to prevent resumption of continuing violation penalties, if any. Any aggrieved party, including the town, can appeal a final order to the Circuit Court of Appeals. Such an appeal is not a new hearing, but is limited to a review of the record created here today before the special magistrate. An appeal has to be filed within 30 days of the issuance of the order sought to be overturned. If you are found guilty, there is an administrative fee of $100. The city representative will present their case first, and the alleged violator will present their case thereafter. I will consider the evidence and render the decision after all arguments are heard. Please note that the hearings are conducted in accordance with Chapter 162 Florida statutes, code enforcement, the town code sections on code enforcement, including Section 7.7, powers of board and the special magistrate, and I take administrative notice of those. Thank you very much. Are there any minutes to adopt?
No.
All right. The agenda, are there any deferrals, additions, or modifications?
No.
Okay, no.
Oh, sorry.
Yes, sir. I would like to withdraw from the agenda, case number 6165, 628, I'm sorry, items 7.3, I should say.
Okay,
Item-
hang on, speak a little more slowly, because
Okay, 7.3,
you want it withdrawn.
yes.
Okay, at the request of the town, 7.3 is withdrawn from the agenda. What else?
7.5,
You want that withdrawn from the agenda?
that is correct.
At the request of the town, 7.5 is withdrawn from the agenda.
7.7,
Hang on. At the request of the town, case number 7.7 is withdrawn from the agenda.
and item 7.15, all of them came in compliance this morning.
And 7.15 are withdrawn from the agenda. They have complied. Thank you. Is there anything else?
No, sir.
We need to swear in any interested parties. Anybody who wants to testify has to be sworn in. You cannot testify if you're not sworn in. Do you want me to do it, or do you want to do it? Want me to do it? All right. If you're not going to be allowed to testify unless you take the oath. Affirm that, and that applies to code enforcement officers as well. Affirm the testimony you will give is the truth and nothing but the truth, so help you God. I do?
I do.
Okay. Let's proceed. Let's proceed with the first case on the agenda.
Case 5680.
We have an attorney present, so we'll be hearing that case first.
Okay, where is that on the agenda? What's the matter number and where is it?
Page 3, item 9.1.
Which number, please? Can you repeat?
9.1 on page 3. For 5680. Good morning. Nice to meet you. Code Enforcement Officer Teresa Malcolm, case 5680. Property site address is Southwest 41st Street in Pembroke Park, Florida, 33023. Property owner is La Estancia of Broward County Homeowners Association, Inc. Original notice of violation was written on March 23rd, 2021. Delivered by regular mail. Notice of formal hearing with a copy of the notice of violation was posted to the property as well as mail certified on 5/18/2021. Notice of formal hearing and affidavit, and a copy of the notice of violation was then posted on the property on 6/16/2021. Notice of formal hearing with the notice of the violation was posted and certified mailed on 9/28/2021. There's pictures to enter into the records. The violations which currently stand that are not cured so far are items number 4 for the dead vegetation in different areas of the property. To remove the dead vegetation from the property and maintain the landscaping throughout the property. Item number 7, property needs maintenance such as painting or pressure washing per building. Item number 8, certain areas of the properties were missing sod to replace and maintain the sodded areas. Item number 9, verify the irrigation pump being used on the property. Also, there's no records of that irrigation system, so it needs to have a permit obtained for it, including plans and inspections from the building department. Item number 11, fallen and rusted parking signs and posts in the parking lot by the main entrance gate. All signs and posts must be maintained and replace the missing signs or faded signs, including the tow-away signs throughout the property. Item number 12, parking lot area needs to be refreshed, pressure wash and repave. Obtain a permit for parking lot reshaped in stripes with the building department. I did a walkthrough with the property president HOA on 10/12. So items number 1, 3, and 5 and partial, since they pressure washed the building, so it just needs to be painted in certain areas, have been removed from the violation since it's cured. Also, items number 2, number 6, and number 10 has been completely removed from the violation due to it being for an adjourning property.
Is there anything else?
My recommendation for this particular case would be 121 days since meeting with the president HOA, Jermaine Dwyer.
How many days?
120 because it's extensive. Mr. Larry Shandell is here. We also had a couple of communications going back and forth. There's a proposed quote that they have, and since it's a HOA, they need to give the owners of the property ample time to gather that HOA, so we're recommended 128 days to have them collect the fees that needs to be due to the HOA to get these violations cured, with the $50 per diem after that.
I'm sorry if you mentioned it, but I didn't catch it. There's various violations here still outstanding. What is the recommended amount of the fine?
$50 per diem.
Is there anything else at this time?
No.
What is 120 days from today? More or less, just so they know.
It'll be January, give me 1 second.
You can.
February 20th? February 20th?
Okay.
February 17th.
February 17th. Okay.
Correct.
All right, sir, you are, your name, your address, your relationship to the property, and then please tell us what you want to say.
Good morning, Attorney Larry Shandell, 635 Southeast 6th Street in Deerfield Beach. I'm the attorney for La Estancia Homeowners Association, and after receiving notice, I've had communications numerous with Ms. Malcolm, and I thank her as well as the city attorney, who I don't see here today. And we accept the 120 days. We have started, as you know, from a homeowners association, we have to obtain 3 bids for each of the projects, and as well as raise the money through special assessment from owners. So we are working on all that. We have contracts that are in the works to be reviewed. So we would accept everything as Ms. Malcolm has presented. 120 days we'd ask for, and certainly I'm hopeful that all the vendors will show up and do the work, and we'll have a great ending. If there's some vendor who doesn't, then I will certainly be in touch with Ms. Malcolm and probably be back here in February asking for a short delay. But I'm okay with everything, and we admit, and you can bring into evidence the photographs and everything else. Thank you.
Right, well, like I said at the outset, unless there's an objection, all evidence that's introduced is accepted into the record. All right, I'm glad that there is an understanding between the parties. I hope the vendors act with due diligence, because it's not just, maintenance that might be required by your bylaws or by best business practices, but, it's a code enforcement matter, so please press them to act timely. So I will enter an order providing that within 120 days, which you heard the date, there would be compliance. If on the 121st day, that is after 4 months, there isn't, the daily fine is $50 based on the evidence that we have heard before us. And the town will either give you a copy of the order, or it will be mailed to you.
Hold on a second, so I give you the copy,
Yes.
please.
Thank you, if I may be excused, and I thank you and the staff of the city to allow us to have the time. Thank you
No,
again.
no, thank you. And since I guess the town has a preference to tender a copy of the order to you,
I'll
just
step
wait, yeah,
aside.
just wait a minute,
I
and
shall.
someone will,
Thank you again.
yeah, thank you.
That's it? That's the only authority? Sorry, Mr. Magistrate, Miguel Nunez, building official, Town of Pembroke Park.
Yes.
I'm going to be presenting case 6158. The property owner is 2250 Warehouse LLC. And this site address is 2250 Southwest 30th Avenue, Pembroke Park, Florida, 33021. This is in violation of the 40-year building safety inspections in accordance with the Florida Building Code 110.15. And the original notice of request for the 40-year was in July 2020. Later, the notice of violation was issued in August 23, 2021, with a formal hearing for today was issued 9/17/2021. At this point in time, the property is not in compliance with the 40-year building safety inspection, and I would like to request, as you mentioned before, $100 administrative fee and $200 per diem with a 15 days in compliance.
Is there anything else? And what was the per diem that you were recommending?
$250.
And 15 days for compliance?
That is correct, sir.
Have you had any communications with the respondents?
No, at this time.
Is there anyone else here to be heard on this matter? The order is going to provide that within 15 days, they must come into compliance. The 40-year building certification is a public health and safety matter, which we take very seriously. And if not, there will be a $250 administrative costs of $100 are imposed. They are in every case. This order, since the violator is not present, this order will have to be, it's just required, you'll have to mail this order to the violator. Next case.
Yes, Mr. Magistrate Miguel Nunez, building official, Town of Pembroke Park. This is case 6159. The property owner is Lake Villa Associates Ltd. And the site address is 2300 South Park Road, Pembroke Park, Florida, 33009. This is in violation of the 40-year building safety inspection in accordance with the Florida Building Code 110.15. This is the first offense. Also, this was notified in 2020, and as of today, there is no compliance. There is a point that I would like to bring. I did receive a letter from Style Build Construction. It appears that they're going to be representing the property owner in the matters of obtaining inspections and for the structural inspections. They're not in compliance at this point in time. They're requesting more time. Unfortunately, we believe that this is a very serious matter, which is a life safety. Therefore, we request a final order for 15 days, $100 administrative fee, and $250 in compliance after that date if they're not in compliance.
Is there anything else you wish to say at this time, Mr. Building Official?
No, sir.
Sir, you are, please identify yourself, your business address, your relationship to the property, and tell us what you want to say.
My name is Richard Pacey. I work for MSL Property Management, who is the owner of Lake Villa Apartments. My address is 6053 Northwest 63rd Way, Parkland, Florida, 33067. To begin with, we're very serious. we are also very serious with, you know, safety and stuff like that. The building department has been out many times. We just put new roofs on this property. They've been there. There is an issue with, you have our business address as 5401 University Drive, Coral Springs, Florida. We haven't been there for years. I finally became aware of this of July of this year. And we retained Carl Forbes originally to do the work. He had some medical issues. Style Built Construction is going to be working with Carl Forbes to get this done. Unfortunately, 15 days is unrealistic in today's environment. We're asking for probably 30 days to 45 days to get this done.
You know, I like to try to be uniform in these violations, so everybody always wants more time, but I don't really hear a compelling reason other than, you know, we need more time.
Well,
You know, I mean, you don't seem to understand this is a public safety issue we're talking about.
Sir,
you know, so-
I completely understand that. I'm just saying is that I contacted them a month ago and I told them that Carl Forbes was going to be doing it. I had no control that he had a medical issue with cataracts. That's what delayed that. Style Built is now working with Carl Forbes, and because of just timing issues, it's going to take 30 days. I mean, we've been a citizen of this, but we've owned this property for 23 years. We pay our taxes. We did roofs. We do it legally. We always pull our permits. This was something originally in 20. It was sent to the wrong address.
Right, but you had to know there would be a 40-year, I mean, you mentioned it's a first offense. I mean, I don't think I'm going to live long enough, you know, to ever hear a second, because it's every, you know, it's after a long interval of time. So, you know, I wouldn't expect a second offense. You're saying.
I mean, I don't think 30 days is unreasonable.
Does the town think that a 15-day enlargement is reasonable under the circumstances, or?
I had to bring, Mr. Magistrate, that this case, this was originally sent to them in 2020. They have
the wrong
a year
address, though,
over.
sir.
This address that we sent is the one that is on records, even in the Broward County property appraisers. So if the property owner did not change the address in the BCPA, I don't know what other address we're gonna send it, because we send it also to the property itself at that time. And during these particular proceedings, it was sent in to 3 different addresses. So we have positive delivery, which is an address in Parkland, an address in Coral Springs, and their
So you sent it to 3 addresses?
yes.
And the main thing that I wanted to hear is the address that you sent it to is the address on file with the Broward County Property Appraiser's Office?
Correct, sir, and also in Sunbase,
In both places?
in both places,
But,
yes, sir.
but I think in code enforcement, you would primarily go by the property appraisers. And it
Correct.
was that address at the time you sent it.
That is correct, sir.
All right. In light of all the facts and the evidence, I regret that I'm going to adhere to the original time frame that I am doing for this kind of violation.
Okay, 2 weeks from now, who do I contact when I don't have it done, so I don't have to start a penalty phase and have to appeal this?
Well, you know, I can't respond for the town, you know.
The process needs to be completed, and you need to submit the report and the final letter to the building department.
I find this very frustrating because I've left like numerous phone calls on your voicemail with never a call back. Okay, we'll live with the 15 days, but if we have to appeal, we'll appeal.
Right, if you have to appeal, you have to appeal, but the fact is that it was sent to all the correct addresses that you had on file. That's a matter of record, sir, and I understand that
I
you
hate
had
to disagree
cataracts.
with you. Okay, that's
All right,
fine, sir.
okay, you can disagree, but the public record speaks for itself, as the
Okay.
law says, okay?
I disagree.
So, you can disagree, but I think the property appraiser's office records are, you know.
You know, we're in a time of a pandemic here.
Right.
And, you know, we're trying our best to do what we can. I mean, part of this inspection is they're going to have to get into apartments where I have 152 of them. And we put notices on doors of 152, and we already got 97 back said that they're not letting us in.
Well, you know, that is an internal issue that you can't lay that at the doorstep of the.
I can't force people, you know, to let me into their apartments to do
Well,
inspections.
when it's a public health or safety issue, you may want to consult with your association
Oh,
attorney.
we haven't. They told us to contact the police and bring the police with us.
No,
So do I really make this a police issue?
well, I certainly can't advise you there, but,
Well, that's why I'm asking for an extra 15 days.
you know, the problem with that, look, so you understand, is that the notices went out last year. and they
Again,
went to the.
I understand. I'm not denying that we were wrong and that it should have been done earlier. If I would have known about this in 2020, I would have started. I did not get involved with this until July of this year, when my property manager said, hey, this came in the mail, what do we do with it? That's when I got involved. I sent Mr. Nunez emails, I've dropped some phone calls, and yesterday was the first time that he responded to one of my emails by saying that we can't delay anything, we have to go forward. So again,
Who is under contract for this?
I'm sorry?
Who did you say is under contract for this, that you have doing it?
We've done, Style Built Construction has contracted Carl Forbes.
That's an existing contract now.
Yes,
You've entered into it.
yes.
And what is the time frame on that?
They told me it was going to take them 60 days. I told them that was unacceptable. I said I can go and ask for 30, and that's the best I probably can get.
You know what, under the circumstances, everything you said, I'm simply, because you seem to be acting in good faith and in reasonable diligence, though you were notified, I'm going to give you the 30 days.
Thank you very much.
I will myself not give you any further extensions. None whatsoever, okay?
I appreciate it.
So, 30 days. If not, it's $250 per day. There is a $100 fine,
That's fine.
or administrative fee, excuse me, I stand corrected. The fine is actually $250 after 30 days. And, you know, I just hope that, you know, this is a extremely serious matter, very severe, and as I said, I'm not going to myself give you any further extension, so.
I completely agree with you. I mean,
right.
we've been
right.
owning this property for
All right,
23
so,
years.
yeah, I just hope if I'm here, I don't see you on some forthcoming
won't.
docket
be
requesting
done.
an enlargement or a modification,
Nope.
because the answer will be no.
Nope, no
All right.
problem. Thank you.
Could you just please wait on the side? Nazi will give you a copy of your order.
Miguel Nunez, building official, Town of Pembroke Park. I'm going to be presenting case number 6168. Property owner is AMITA Development LLC, and the property address is 2350 Southwest 30th Avenue, Pembroke Park, Florida 33009. This is 40-year building safety inspection violation in accordance to the Florida Building Code, Section 110.15. This is their first offense. This is, they were notified back in 2018. And
2018?
the original notification, yes, sir.
Okay, and that was properly addressed and.
That's properly addressed and completed.
2018,
That is correct.
okay.
In August 24, 2021, we sent a notice of violation to all the parties that are included in the Sunbiz and in Broward County Property Appraisers. And for compliance, in October 5th, 2021, the formal hearing was created because of non-compliance, and as of today, there is no compliance whatsoever. Therefore, the town is requesting the property to be in compliance with the safety inspection within 15 days. If not, a fine of $250 per day with an $100 administrative fee.
Is there anything else at this time?
No, sir.
I'm going to interrupt the meeting for a second. If your case has been withdrawn from the agenda, you may leave if you wish. You don't have to stay for the hearing. Thank you.
Yes, sir.
Okay, is there anyone here from AMITA Development? Okay, the order is going to provide that there has to be, which is the standard for this offense, compliance within 15 days. If not, there will be a $250 per diem or per day fine. The $100 administrative fee are all hereby imposed in this order, and the town will have to duly serve mail a copy of this to the respondents because they do not appear to be present.
Miguel Nunez, building official, Town of Pembroke Park, case number 6297. Property owner is 2400 Southwest 30 LLC. The property address is 2400 Southwest 30th Avenue, Pembroke Park, Florida 33009. This case was originally sent to all the parties associated with the Broward County property appraisers and the Sunbiz. On this particular, this was in 2019, I'm sorry?
2019, the original notice for the 40 years was sent?
Correct.
2019,
2019.
okay.
In September 2021, the notice of violation was issued. By not being in compliance, October 5th, 2021, the formal hearing was created. At this point in time, the building is not in compliance. I forgot to mention, this is their first offense. And at this time, I'm requesting 15 days for compliance, $250 per diem, and $100 administrative fee.
Is anyone here from the respondent 2400 Southwest 30 LLC? Based on the evidence that I have heard, the order to be rendered here is going to provide that there must be compliance as a standard for this offense within 15 days. If not, there will be a $250 per diem or per day fine, and a $100 administrative fee is imposed. And that is what the order in this particular matter will provide. And as noted, respondents have failed to appear. For the record, the town will have to mail a copy of the order to them. Next case, please.
This will be case 6302. The property owners is CROSSWINDS and COUNTYLINE LLC. Sorry, the site address is 5525 Southwest 41st Street, Pembroke Park, Florida 33023. This is a violation of the 40 years building safety inspections in accordance with the Florida Building Code Section 110.15. The initial request for this particular property was done in 2016.
2016
Yes, sir.
was the original request?
Original request for the 40-year safety inspection, and it was sent to the information that we have in the Broward County property appraisers.
The information on file at that time?
That is correct.
Okay, all right, go ahead.
In September 2021, the notice of violation was issued, so they are in compliance within 15 days. Obviously, within 15 days, in October 5, 2021, it was not in compliance, and a notice of formal hearing was issued. Obviously, as of today, they are not in full compliance. However, this is their first offense, so therefore the town is looking for their being in compliance within 15 days. If they're not in compliance within 15 days, $250 per diem and $100 administrative fee.
And the original notice, you're certain per your records, was sent 5 years ago, to the correct address?
That is correct, sir.
It was just said as some letter was sent in by regular mail. We did not know about this at all. The first time I ever heard about
First off, what is your
Okay.
name?
Frank,
your relationship to-
Frank Rosen, managing member, CROSSWINDS at COUNTYLINE LLC. My address is 7351 Promenade Drive, apartment F501, Boca Raton, Florida 33433. So as I said, I don't know about this letter in 2016, which went out by regular mail. We never received it. I first heard about 40-year certifications when I was watching television and I saw what happened down in Miami Shores. At that point, the day after that, I started contacting
Right.
engineering firms to get our certification done. I was told to be put on, I was put on waiting lists, continued calling, no action. We finally, let me get my facts straight. Okay, we received this notice of violation on September 20th. What we did was we were able to find an architect who did the report on the 40-year certification on October. We hired him on October 4th, and on October 5th, we got the notice of violation and the hearing date. I have the report for the 40-year certification. We have always maintained this building in a safe manner. We never have any violations, or any violations that we have are corrected immediately. So I think code enforcement can go along with that. I don't think we have anything, we have nothing outstanding. On the building certification report, the only issue, there were no safety issues. The only issues that they found is they want us to replace two of the roofs of the four buildings, even though they don't leak, but we have already contracted a roofer. A permit has already been put in. A notice of commencement has been put in, so that's being taken care of as we speak. I have the contract, the permit, and the notice of commencement. The only other issue was a couple of electrical issues, none of which had anything to do with any kind of safety. One was replacing the exit lights that were there with new ones of a different caliber that we've had, in the building the whole time for 20 years. Fixing the disconnect and some of the wiring on the AC units which are on the roof, and putting in a grounding pipe by the pool pump to ground it. So that's where we stand at this point. We've already got one estimate for the electrical work. We're waiting for another one supposedly today, and we're working as fast as we can to get everything corrected.
No, and thank you for that narrative and that explanation, but let me ask the building official for my edification, because as I understand the violation, it's not so much the contents of the report, but the report has to be timely submitted, and then you will evaluate what needs to be done, or am I wrong?
You're partly correct, sir. Yes, you're correct. One of the issues based on Broward County Policy 0505 in regards to the 40-year inspection, the whole process needs to be in compliance before and a certain time. The report needs to be submitted to the building department before if any repairs are required. Those repairs needs to be performed after they obtain a permit. they cannot start doing anything that it shows on that report without a permit, because that will constitute another layer of violation.
Right, unpermitted work.
Unpermitted work, correct? And then they have certain time to complete the work in accordance to the same policy. Therefore, the whole process needs to be completed before the violation is in compliance. So,
No, you've explained it adequate, you've explained it satisfactorily to me. I
Thank you, sir.
understand that. So it's submittal and permitting of the required work.
Correct.
So do you understand that?
Yeah, so I have the report.
But you haven't submitted it to the town
No,
official?
it was just completed on the 14th. And we just received it this past Friday.
All right, well, I certainly can't advise you as to what to be doing, but you need to have submitted that through regular channels to the building official, to the building department, electronically, which is how most things are done now, or, I don't know that, submitting it at the hearing, well, I'm not going to advise you on that, but, Mr. Building Official, how can you submit that report?
they need to submit it through the building department directly.
Right. And you need to, you're here, you should go to the building department,
Right.
find out how it's to be done. Were you there in 2016?
We've owned the building since 2001.
Okay. And is it your testimony, because you're under oath, right?
Excuse me?
You're under oath. You're under oath, right?
Yes.
Okay. Is it your testimony that, under oath, that you did not know about that 2016
did not.
notice? And is it, of course, ignorance is no excuse. I don't need to tell you that. How you can own a building and not be aware that that's a legal requirement under the Florida Building Code is beyond me. But you say you were
Well,
unaware.
we maintain the building in a safe manner ever since we owned it. As we have had not any issues with the building department or code violation in that whole time period. So, it's not like we're not trying to take care of it. As soon as I heard about this, I took action to get it done.
Well, all right, you've in light of all the testimony from the building official, which I defer to, I'm very mindful of, but I also listen to everyone, and because in my view, the idea of code compliance is compliance, not monetization, I'm going to give you 30 days. Now, 30 days is all, this is a very serious offense, it's a very serious offense. So whether you were unaware of it, or I'm going to accept that as true.
Well,
That's why I'm going to give you the 30 days,
Okay.
but
I think that should be sufficient, because we have already contracted for the roof.
I would not give you one other day,
Okay.
all right?
You
So-
also have to understand, I lost my train of thought.
I have to understand about the contractors or?
Understand about this first letter that we supposedly got. In 5 years, that there was not one follow-up until September of this year to say, why haven't you done anything in this time period? Not one follow-up.
I understand, and I'm mindful of that, and in light of all of that, I'm giving you 30 days. But again, it's not the town's responsibility, it's the owners.
Okay.
I mean, but I would also encourage you to visit building while you're here.
Yeah, I'm going to go to the
And
building
find
department
out
right
how
now.
to submit that report, and be sure that you do everything on time, because again, I'm not gonna,
Okay.
I myself am announcing to you that I would not intend to modify or extend this order, or,
I don't believe it should be a problem.
all right? And, so in light of all that, you have 30 days, if not $250 per day. The $100 administrative fee is imposed. And again, I'm announcing for the record that there will be no other extension or enlargement, okay?
Please hold on a second, I will give you a copy.
Miguel Nunez, building official, Town of Pembroke Park. This is case 6303. The property owner is 3163 Building LLC and 3163 West Liquors LLC. The property address is 3153 West Hallandale Beach Boulevard, Pembroke Park, Florida 33009. This is a 40-year safety violation in accordance to the Florida Building Code, Section 110.15. This is their first offense. And, Mr. Magistrate, the initial request for this particular property
Yes, sir.
was sent in 2016, and it was sent to all the appropriate owners and Broward County property appraisers.
So the notice was appropriately given in 2016 to the owners per the addresses on file.
That is correct, sir.
Go ahead.
Now, in September 20, a notice of violation was issued, and no results from that notice of violation happened. In October 5th, 2021, the formal hearing was created for this time, and as of this time, this is a very unique case. But
Why is that?
The reason for that is because they submit the report, but the report was incomplete and insufficient. They submitted yesterday. I took around 5:30, and this morning we issued like 4 or 5 phone calls from staff trying to contact the engineer and the owners so they can correct the report, so that way we can withdraw this case from here. But there was no response. Unfortunately, because they were not in compliance, and in order to be fair, the other ones that has been in compliance at the time, we requested 15 days to be in compliance, $250 per diem, and $100 administrative fee. Even though I feel confident that they will have it ready, we will continue trying to communicate with them.
Is there anyone here from the respondents? Okay, based on the evidence of record, which is admitted, and the unrebutted testimony of the building official, the order is going to provide that they must come into compliance within 15 days, which is the norm for this kind of violation. And if not, there will be a $250 per diem or daily fine, plus the $100 administrative fee is hereby imposed. Without meaning to advise the town, which is not within my purview, I would urge you and recommend that you put your communications with them, at least one of them, in writing in an email confirmation with a return receipt, so there's no issue later if this ever comes before someone again about that they didn't know or that they weren't aware, because, I mean, you can establish that they were called by having someone testify, but it's not the same thing as having an email saying you need to correct this by such and such a date.
That is correct, sir. The intent of the building department was to be proactive with them, to help them, and not reject the.
No, and I understand, but I'm just saying that for your own records, I would urge you to send them an email.
It will be done.
Thank you. So that is what the order provides. It's been entered. Thank you. Gracias. Okay, our next case.
Sir, my name is Miguel Nunez, building official, Town of Pembroke Park. This is case 6306. The property owner is Pembroke Park Warehouses Holdings. The property address is, let me see, hold on a second. The property address is 3121 Southwest 21st Street, Pembroke Park, Florida 33009. This is in violation of the 40-year safety inspection in accordance to the Florida Building Code, Section 110.15. This is their first offense, and I would like to notify you that the initial request of this requirement 40-year was done in 2016 to the property owner on record and in the Broward County property appraisers. In September 22nd, 2021, the notice of violation was sent, and in no compliance, and in October 5th, 2021, the notice of formal hearing was issued. At this point in time, the building is not in compliance. Therefore, we are requesting to be in compliance within 15 days. If not, $250 per diem and $100 administrative fee.
Is there anything else at this time?
No, sir.
Thank you very much, Mr. Building Official. Please state your name, your address, your business address, your relationship to the property, and tell us what you wish to say.
Hi, good morning. My name is Nancy Romero. I'm the general manager for Pembroke Business Park. Our offices are 3150 Pembroke Road, Pembroke Park, 33009.
Morning.
Good morning. We actually became first aware of this situation in October when it was posted in one of the tenants' unit. Then, of course, it was followed up with the correspondence via mail. As of this year of October, we were not aware of what happened back in 2016, which puzzles me because we did put a new roof on this unit about, I want to say 6 years ago. And at that time, it was not mentioned to us that this was an issue, the 40-year cert. Also, about a year ago, we recently closed up a violation that we also had in that building. It was closed, permitted, et cetera, et cetera. In other words, we have taken action as well. We've hired an engineer to start doing the plans to see what are the violations, if there's any, for the building itself, because we have, through the years, upgraded, like I said, anything plumbing, electrical, roof, et cetera, et cetera. So we're just a matter of getting the engineers involved, and as a matter of fact, we're having a meeting tomorrow.
Have you contracted them yet?
Yes, we have.
You have an agreement with them at this point?
Yes, we do.
And I guess what you're articulating to me, or what you're saying, is that, again, you're another owner or another property manager that seems unaware of this building code requirement, but that you met with the town and this did not come up. Is that what you're?
Yeah, that is correct. Not personally, but like I said, I've
Well,
had
then-
general
then-
contractors.
Who met with the town? Because then that's hearsay. I mean, I can accept hearsay, but if you can't tell me who.
Well,
who
when
met-
we closed the permit, it was Levi, what's his last name?
Oster Construction.
You are who?
My name is Doran Frey. I'm a manager with Oster Construction, and we've been working with Pembroke Park to bring in compliance several units there. And as a matter of fact, just 1 or 2 days ago, we put some plans with the city.
But that was on a different unit. But in particular, his company was the one that closed our permitting, I believe it was last year.
Did you meet? Okay, no, thank you.
I personally
No,
did
not
not-
you, but did you meet with the town last year?
His partner did.
My boss, my partner, yes.
Your partner did.
Yes, sir.
Did the 40-year certification come up?
Not to my
I mean,
knowledge.
yeah, you're under oath, so
Yes,
I'm
sir.
asking you.
Not to my knowledge.
And were you, as a contractor working with them last year, aware of it?
Yes, I've been on the property for 11 years now.
So you're admitting you're aware of the 40-year certification?
I am now, yes. As
You
of
are-
October, I am aware of it.
As of October, all right.
Yes, and we are trying
Okay.
to comply with it 100%. Like I said, we have been upgrading that particular building for the last 7 years now. So we're not denying that it's not, under compliance or whatever. We're just saying we're agreeing, we're taking care of it, and hopefully within 15 days or less or more, I don't know what the procedures are as far as how long it's going to take in place, but we will take care of it.
Well, yeah, this particular kind of violation is a serious public safety violation. So I'm going to ask, again, with no slight intended, but I'm going to ask your contractor, is 15 days sufficient for you?
No, we don't have a plan.
15 days, Your Honor, is not realistic because the architect that we're working with, they're backed up with, other work, and they advised us that we should be getting approximately 60 days.
Well, that's not a possibility because this is a very serious violation. So I'm going to give you 30 days, okay? Because you seem to be making an effort. However, as I've told others here, and I try to treat these cases in a uniform manner, you've at least appeared, you've undertaken certain actions, but, this is something that can affect the lives of people, because we don't know the circumstances except that it's very important to know that the building is structurally sound and, so 30 days. There will be no other extension. There'll be no other enlargement. The fine will start $250 a day in 30 days and will continue thereafter until there is compliance. $100 administrative fee is imposed. Am I clear?
Yes, sir.
Okay, so I'm going to give you the 30 days because you appeared and seem to be taking some actions. The fact that the guy has other work or whatever, I don't know if that other work is a 40-year certification, but that's of no concern. That's immaterial. You may need to find someone else right away. Okay? So that's what the order provides, 30 days, no further extensions. And if you want to wait a moment, you can get a copy of it, please.
Okay,
Thank you. Thank you for coming in.
Okay, sir. Case number 6307. The property owner is M.G. Wilson, LLC. The property address is 2701 Bryan Road, Pembroke Park, Florida, 33009. This is a violation of the 40-year building safety inspections in accordance to the Florida Building Code, Section 110.15. This is the first offense. And just to let you know, Magistrate, the initial request was sent in 2017.
2017.
2017, correct. I would like to point out that in this particular property, there are 7 buildings that are marked as a requirement based on the Florida Building Code, and each one requires a separate report. It just doesn't have one folio number. Now,
And that's because they're each
separate building.
They're separate buildings.
That is correct, sir.
Okay, they're not interconnected in any.
No, sir.
No, okay, I understand. Go ahead.
Now, again, like I mentioned, this was the initial request in 2017. On September 22nd, a notice of violation was sent to the property owner. Obviously, no action happened at that time. On August 5th, 2021, the formal hearing was issued, and at this point in time, they are not in compliance.
Is there anything else you want to say at this time?
Yes, I believe this property, it was brought to my attention that they tried to submit one report for all 7 buildings, and it was sent back because of the individual buildings requirement. So it was not in compliance at the time, so we have not received it back yet, or at least I haven't seen it as of this morning.
So if, to be clear, well, it's being heard this morning by the respondent, but when the report was returned to them, do you know if the town communicated that each individual building would require a separate report? You said that to
Yes,
them.
sir. It's right there on the notice of violation, and it stays that way.
All right, is there anything else at this time?
No, sir.
Thank you. Sir, you are your name, your business address, your relationship to the property, and then tell us what you wish to say.
I'm Robert Allen. I'm the manager of Armadillo Mini Storage at 2701 Bryan Road. That's also my address. I have an apartment in the property. We're a self-storage facility, and I'd like to clarify a few things first, sir. This notice was taped to my window by the front door. I received it on October 9th. That's the first time I became aware of this. Further clarification. M.G. Wilson, LLC, owns the land. The buildings are owned by Armadillo Mini Storage. Wilson is in Boston. Armadillo Mini Storage works out of Corpus Christi, Texas. My boss became aware of this violation also around the same time. We scrambled, found a registered engineer. Yesterday, I submitted 6 reports. There's only 6 buildings, not 7. I submitted 6 reports to the building official with a check for $2,100. The building official demanded a cover letter. I called the engineer. He says, there is a cover letter on each and every thing. And I said, well, the building inspector wants a single cover letter for the whole project. And he says, he does not need that, it's already there. I've submitted 2 other proposals, and he accepted those before. Now, Jeffrey Lewis, who is the Emergency Operation Manager Permit Specialist, knows me, and he knows the property.
He's with the town?
He's with the town. He works for this fellow here.
Yes.
Now, he knows who I am. How come we didn't get the information? How come my registered engineer's reports aren't accepted? What's going on?
Well, you know, I certainly can't speak for the town or advise you. That's, I'm simply the magistrate. But, you know, I believe that under Florida law, in terms of the violations and things like that, so if you have an arrangement with the owner where you own the buildings or you have a long-term lease of the buildings or whatever, that's, the law says they go by the real estate owner of record. That's who they are supposed to notice per the law. Like anything else, because you know this Jeffrey or whatever would be a courtesy. But under the law, it seems that they noticed who they were required to notice. Now, I do want to make one inquiry. And I understood fully, he explained it very well, the building official's explanation that each detached building requires a separate report. But why would there need to be a cover letter for all of them if they have to be submitted individually?
No, they need to be individually. Individual report for each building. Each building acts individually.
But he just said that a cover letter was being required for all buildings, as I understood his
No,
testimony. Is that what you said?
I have not received that information, nor I talk about it. And when I'm looking about 7 buildings, I'm looking on the sketch of the Broward County property appraisals. As you can see, there's 7 buildings in there, in excess of 3,500 square foot.
Have you seen that sketch?
I can't
And this is the
help
Broward
you
County
there.
property
There's only
appraisals.
6
Why
buildings.
don't you look at the exhibit, sir? It's on the wall. I mean, that's your property. It shows 7 buildings.
Okay, well, it's wrong. I'll be glad to take you down. There's only 6 buildings.
Well, you may need to, what does he need to do to?
He may need to contact the Broward County property appraisers to modify the sketch. And at that time, we'll reevaluate the property and to make sure, because we go by the Broward County property appraisers.
Right, so that's what officially is on file and presumably submitted by the owner, right? Or-
That is correct.
So, you know, I understand what you're saying, but that's what has been submitted to the county officially.
Okay, well, they're wrong also then.
Right, I know, but it was submitted by someone in your organization. The issue about the individual cover letters or whatever, I can't resolve that, but
Does he have my report there in front of him? Do you have my report?
No, sir, I have nothing.
Okay, I was talking with Jeffrey Lewis on the phone yesterday. You walked by Jeffrey Lewis, said you need one cover letter.
Per building.
No, you said 1 cover letter. And I got on the phone with Jeffrey and the lady there, and they said, okay, this is how you have to write the letter. It's got to be 1 letter. I talked to the engineer, he says, no, I'm not giving you another letter.
I did not speak with that unless.
All right, well, all
okay?
right.
My staff is very well versed in the 40-year inspection because I've taken the time to train them.
Okay.
And they know it's 7 buildings and it is 1 building, 1 report per building. 1 report complies also with 1 letter in accordance to Broward County Policy 0505 on the 40-year inspection. A copy of that it was sent in 2017 and it's on our website and public records. Therefore, that needs to be 1 cover report to safe and occupancy per electrical and structural per report. That means per building.
We complied. We complied with that.
I have not seen it, sir. I haven't received it yet.
You had it yesterday. I have a copy of the check I wrote to you yesterday, right here. Jeffrey Lewis made a copy of the check I gave you. You have all 6 reports with 6 cover letters. Why should I be penalized? Because, first of all, Mr. Wilson didn't notify us. Why should I be penalized because the Broward County is wrong? Why should I be penalized because you don't know what's going on in your office?
well, let's not get into a personal exchange here. I'm just trying to, actually, I was trying to assist you. First, let me tell you that as a matter of law, if the public record shows 7 buildings, and that was submitted by the owner, you have to correct that. That's not the town's mistake. You need to correct it, sir. You know, not everything is the fault of the government. I know everybody'd like to
Okay.
blame everything on the government, but it's just not so. So, secondly, in terms of the individual reports, I would think that that's a matter that can be straightened out. If the building official, who's the director of the department, is saying that it's individual reports, and you had individual reports, then whoever advised you, do you know who that person is, that you needed one report?
Jeffrey Lewis.
Okay, well, then it seems that per his director, he's been corrected.
All right, I can't give you a report on a fake building. Otherwise, a ghost building, I can't give you a report on that.
Right, well, you have to listen.
I'll take care of that, but at the
listen to me.
meantime,
Listen.
I want this to be accepted, that I have submitted a
Right, well,
engineered report.
Right. I am, it's not within my purview, but I would certainly, it's not within the terms of this hearing and whether there's a violation. But all I can tell you is that I think it's clear what they're requiring, that it's one report submitted to the town for each building. And it has to be the buildings that are on file. If that is what's on file, then you need to quickly call the county or go see them at the government center and explain that you're in a code enforcement case and that sketch is wrong, and show them a new one with the 6 buildings and get them to replace it. Or, you know, I can't advise you, but you need to do something there. It is not their fault that is that way. So I think in light of everything I've heard, I'm going to give you 30 days. You have to work this out. However you can work it out, I think I've given you enough guidance and advice as to how to do it.
All right.
You know, within 30 days. If not, because there seems to be some disconnect between you and the town, but it seems like you're undertaking activities. But again, these are very serious matters. I don't think that, since these are storage facilities, we're not talking about human life, but we're talking about loss or destruction of property. You'll have 30 days to comply. If not, the standard fine for this violation is $250 per day after 30 days, and the $100 fee is imposed on every single case that comes here. And I strongly encourage that you meet with the town officials and that you go see the county, you work out the sketch issue, and you work out the proper format for submission of the reports so they can be formally submitted and you can hopefully resolve this. I do not have the power to do it, but
I think this can be resolved by the building department accepting the fact that M.G. Wilson is not the owner of the buildings.
Right.
Armadillo Mini Storage is, and Armadillo Mini Storage has submitted the
But
engineered
listen,
reports.
As much as, as somebody else said, this about a cliche, this is not we're not about, this is not rules made by men, it's the rules of law. And the rules of law are that the owner of record, and if the county appraiser shows the owner of record to be M.G. Wilson, because they own the dirt, they own the real estate, that's all the town has to contend with, because that's what the law says. So if it's really M.G. whatever, you have to work that out with the owner. But get the owner to change the notice address to you, I don't know, whatever. But they notified the owner correctly because it's the owner of the real estate who is responsible under the law. So, again, I can't give you a crash course on this. I've tried to be as helpful as I can be. That's what the order provides. And, we've discussed your options. I hope you act on them because I am not going to give any further enlargement of this time. Thank you. If you want to remain a moment, you can get a copy of the order.
Okay. Thank you.
More. Miguel Nunez, building official, Town of Pembroke Park. I'm going to be presenting case 6308. The property owner is Hallandale Retail LLC, and the site address is 2940 Country Club Lane, Pembroke Park, Florida, 33009. This is a violation of the 40-year building safety inspection that has not been completed in accordance to the Florida Building Code, Section 110.15. Right now, is the first offense, and the initial request was sent to the property owner on record in accordance to the Broward County Property Appraisals in 2017.
2017.
2017, yes, sir. And no action was taken by the property owner. Therefore, in September 22nd, 2021, a notice of violation was written to be in compliance. No action has been taken. Therefore, in 10/5, the formal hearing was submitted for today to be in compliance for an additional 15 days, and they were not in compliance. As of right now, there is no compliance whatsoever on this particular building. Therefore, we are requesting the property to be in compliance within 15 days. If not, to pay $250 per diem with an $100 administrative fee.
Is there anything else at this time, Mr. Building Official?
No, sir.
Is there anyone here from Hallandale Retail LLC? Okay, the order to be entered provides as a standard 15 days to comply. If not, there is $250 per diem or per day fine, plus the $100 administrative fee. Is hereby entered. And again, noted for the record that respondent is not present. And do you want to proceed to the next case? Fine
Yes, sir.
line?
Yes, sir.
Okay, that is case number 7.13, Fine Line Interiors.
It's 7309, sir.
Yes,
Case 7309. The item is 7.13.
yes, I know that.
Yes, sir.
But I'm going to mention the agenda number.
Okay, thank you,
Okay,
sir.
yes.
My name is Miguel Nunez, building official, case 6309. The property owner is Fine Line Interiors, Inc., and the property address is 2530 Southwest 30th Avenue, Pembroke Park, Florida, 33009. This is their first offense, and this is in violation of the 40-year building safety inspections in accordance with the Florida Building Code, Section 110.15. I'd like to inform the magistrate that the initial request on this 40-year was sent to the property owner on record in 2017.
2017, okay.
2017, yes, sir. And no actions was taken at that time. On September 22nd, a notice of violation was sent to the property owner, and no action was taken, giving him 15 days to be in compliance. No compliance happened at that time. Then in October 5th, 2021, an additional 15 days was requested, so that way they're in compliance and for the formal hearing, before the formal hearing, and at this point in time, no action has been taken. I have not received any completion of this particular process.
Sir, there's one thing you just said that I want to ask you about. You said on October 15th, a further 15 days? was
October
it?
5th, I'm sorry, October 5th.
October 5th.
I'm sorry, October 5th, I'm sorry.
And they themselves, someone from them contacted you and asked you for 15 days at that time, or contacted your department?
No, we give him 15 days, so we can give him a total between the process, 30 days.
All right, I
Which is the
understand.
original notice of violation, and then the hearing, total 30 days, which is reasonable time for them to have in compliance.
All right, you're referring to the time span between the notice and today.
Correct, sir.
All right, I understand. Is there anything else at this time?
No, sir.
Sir, your name, your business address, relationship to the property, and say what you want to say.
Good morning. My name is Roe Damad. I am employed by Fine Line Interiors. The address is 2530 Southwest 30th Ave, Pembroke Park, Florida, 33009. And I'm here to notify you that we also never received that first letter in 2017 or We don't know. And when we received this on September 22nd, we immediately got someone to come out and do the inspection, and I'm here to notify you that we did do the inspection. It was performed on October 11th by Specialty 1 Building Inspections, and we are awaiting the reports as of right now.
So, and I appreciate your candor. So your testimony is that on October 11th, approximately 10
At
days.
11 o'clock.
The inspection was done.
Correct.
This company is rendering a report to you. The building 40-year certification report is being prepared by them. Did they give you any idea of when they would submit that to you by?
To be honest with you, I'm not aware.
I appreciate your honesty. So I am going to provide that you have what you need to do when you go back. Again, our standard here is 15 days for this offense, so
Okay.
you need to go and tell them. Since you have, again, I appreciate your candor, that's what it's all about, but since they've already done the report, that they need to submit it as soon as possible, or immediately, or,
Yeah,
and
as soon as
to
we
the-
get it, we will.
Right, to the town, the way it has to be submitted in the appropriate format to the town building department, correct?
Correct, sir.
So you're going to have 15 days to comply,
Okay.
and if not, as you have heard from the other cases, it's a $250 per diem or per day fine after the 15 days, and there's a $100 administrative fee for each case. And if you please remain a moment, you can get a copy of this order. And in fact, I would encourage you to, you or the owner or someone to speak to them and tell them that this is a pressing matter.
Absolutely. Thank
All
you
right?
so much. I appreciate it.
Thank you very much for coming in. Hang on a minute. ¿Cuánto más? ¿Cuánto más hay de esto? No, uno más. Okay.
Sorry.
Okay.
Miguel Nunez, building official, case number 6310. The property owner is Lake Forest Baptist Church, Inc. The property address is 3610 Southwest 48th Avenue, Pembroke Park, Florida, 33023. This is in violation of the 40-year building safety inspection that has not been completed in accordance to the Florida Building Code, Section 110.15. This is their first offense. And, Mr. Magistrate, to inform you, the initial request for this particular property was done in 2017, and as of today, they're not in compliance. On September 22nd, our customary notice of violation was sent for them to be in compliance within 15 days. They did not. So in October 5th, I don't want to make the same mistake. On October 5th, 2021, the notice of formal hearing for today, so they're in compliance, an additional 15 days was issued for a total of 30 days. And as of this moment, there's no compliance whatsoever on this particular property. Therefore, we're requesting the property to be in compliance within 15 days. If not, $250 per diem be imposed and $100 administrative fee.
Anybody from the respondents, Lake Forest Baptist Church here? Lake Forest Baptist Church? Okay, the order to be entered will provide as a standard 15 days to comply with the 40-year building recertification. If not, there's a $250 per diem or per day fine. The $100 administrative fee is imposed as well. And the town will have to mail a copy of this order to the respondents who, let the record reflect, are not present and have failed to appear.
Thank you, sir.
Thank you very much.
We're going to continue the order of the sign-in sheet. We're going to start with case 4589.
On what page is that?
Page 5, 12.2.
Thank you.
Okay. Chief Code Enforcement Officer Jocelyn Ramirez, case 4589. Property owner JNUV LLC, property address 1730 Southwest 30th Avenue, Pembroke Park, Florida. This matter is here today for a confirmation of fine and an abatement of fine.
All right, please present each matter to me.
Okay. Case 4589 was for a violation that was issued. And just for the record, I am presenting these cases on behalf of former Officer Jeffrey Lewis. So all of these cases that I'm going to be presenting for this property owner are on behalf of that former employee.
You're familiar with the matters.
Yes, I'm familiar with the matters. And I would try my best ability, to answer all your questions. Okay, so case 4589, the violation was for the recertification of 40-year inspection. At this current time, they have complied. The compliance date was January 29, 21. A notice of hearing to confirm the fine and to abate the fine was sent out by certified mail on October 1st, 21, and posted to the property on October 4th, 21. The fines, the per diem fine was $50 per day, which accrued for 308 days from March 27, 20 to January 29, 21. Accumulated to $15,400. The town commission, there was a time where they suspended the fines from March 18, 20 to June 10, 2020, which was a total of 75 days at a per diem of $50. So it was a reduction of $3,750. And at this time, the property owner has made the $100 administration fee at the time of the final order on February 27, 20. The total accrual of the fines with the subtractions of the suspensions of fines is $11,650, and is the town's recommendation to reduce this fine by 90%, which would be $1,165. The property owner is here. Please state your name for the record and how you relate to this matter.
Tell me, before we do that for one moment, tell me what the amount that you're recommending that it be abated to is?
$1,165.
I'd like to note that there's a clerical error in one order that provides the fine is $11,250, where I think you said $11,650. I consider that a harmless error in light of the pending order of abatement, but I just want to note it for the record.
Yes, noted.
Give your name, your business address, your relationship to the property, and what you want to say about this, please.
Yes, my name is Gadi Ramim. I'm the owner of More Construction. My business address is 3570 Northeast 167th Street, North Miami Beach, 33160. I'm the contractor that contracted by the family to first take care of the 40-year certification and the violation that was, occurred when Mr. Jeffrey used to work in that office, allowed me to start to start. I'm gonna talk about not only this one, I'm gonna talk about all the one. We have about 4 or 5 of them. So my statement is including all
Well,
of them, if you don't mind.
No, I don't, but we're only here on what you just heard.
Yeah,
I'm
no,
not hearing
there is-
anything else, okay?
Okay.
So, all right, I mean, it's not on the agenda, so I
Okay, sir.
can't. You really should limit your comments to what we just heard.
Okay, Majesty. Yes, Majesty. Okay, so what happened is that I'm going to start. We were contracted by this family to take care of this violation. We did a 40-year certification. We passed it successfully. As soon as we got it, we complied with that. There was other violation that accumulated at the same time. We took care of that as well, to the satisfactory of the city of Pembroke Park. We were meeting on site few times with Mr. Jeffrey, the code compliances, to go over things. If he oversee things that are future to become a problem, we took care of that as well. And actually what happened is that today is the mark of the 30th day that the owner of that building, Mr. Uri Mayors, passed away after 6 hard years of fighting cancer. And,
I'm sorry?
Thank you. May you rest in peace. And we came here not because we came to argue with the city. When I was contracted by him, that thing was going for a long period of time. And Mr. Uri Mayors was, when he contracted me, we not only became a contractor and owner relationship. He asked me not only to repair and fix this violation, he asked me to repair the relationship with the city of Pembroke Park. And we did everything we can with Mr. Miguel that left. We met with him a few times. We hired the best engineers we could, and we really did everything in our power to bring back the building to the shape that it should be. The sequence of events occurred when, during that time of his being sick, he was, leaving everything else and concentrating on seeking the right medicine, and was traveling around the country and some parts of the world to see the best professors. But put that aside, the building was rented to a company, a cabinetry company, and in addition, because he did not want to have any hardship on that, he asked them to give them almost a year and a half free of rent to fix violation and to pass the 40 years inspection. Well, if you look at the record, they haven't done anything much about it. Not only that, they did not pay the rent, but that's a different story. And they left the building with the full merchandise and things. They just deserted the building. Luckily, we got in on time, and we happened to do a good few things on behalf of Mr. Mayors. We donated all the cabinetry for a contractor who shipped them for free to Haiti. So I think half of the islands of Haiti have a kitchen cabinet because of us. So that's the good part. We cleaned the warehouse. We brought everything to be safe as far as plumbing, engineering, roofing, safety. The exterior panels were changed, so the beautification of the building is going to look nice when you drive approaching the I-95. We did everything in our power. Now, we are not coming here to ask for forgiveness or to wipe out everything. We would like you guys to consider all the hardship that the family been through, and we would like you to consider charging us and lower the price to the matter of the time that it was noticeable that you guys spent on the file when you wrote those violations, when you drive by the city, when you inspect the property. We would like you to eliminate as much as possible so the family can take the time and recuperate from these hard conditions. And again, I said, this is only one violation, but we did comply with every request of the city, and as of the present today, there is no open violation. The building in good standing, the 40 years passed successfully, and I appreciate if you guys take it into consideration. I know. I would love, if it's possible, Mrs. Mayors is here. and she
Nasli is
would like
making
to
the
say-
corrections.
What? I'm
If
sorry.
you're looking for Nasli, she's making the corrections. The corrections you noted, the clerical errors.
Well, no, it's,
Teresa?
Doesn't matter.
go ahead. It's-
I'm sorry.
Your Magistrate, I would just like to summarize this thing, and I would like to have Ms. Mayors to say a few words. And thank you very much for your time.
Thank you.
I'm Judy Mayer. I can't talk.
Good morning, my name is Joseph Serdar. I work with the engineering firm hired VLC 1955 Hollywood Boulevard, Hollywood, Florida, 33020. When the property owners first received the 40-year certification, the initial engineer passed away during the process. Then our firm was retained by the owners to perform this inspection report. We noticed, as he mentioned, that the building had deficiencies. We had numerous issues with the tenants that were in the building. We applied for building permits. We received the building permits to perform the necessary upgrades and modifications necessary to comply with the 40-year recertification items. During this process, their initial contractor, he didn't perform the work. He left the job abandoned, so they had to actually hire this new contractor firm to continue the project. Through this whole, I would say almost 2 years of going with the city, the permits expired, applied for reinstatement of the permits, communicating with Mr. Miguel. We had numerous inspections on site to go over field items that were noticed during the inspections, numerous meetings here at the office to go over items which Mr. Miguel wanted corrected above and beyond what the initial permit was submitted for. And we found ourselves today, as he mentioned, the permits have been approved. I believe a few weeks ago he had the final inspection for the necessary permits, so everything should be closed out. As he mentioned as well, the 40-year certification report has been submitted, has been passed and approved. So on our end, we have done everything that we could. Of course, last year when it was hard to meet with the officials and we had hiatus, we've done everything in our power to get this building up to where it needs to be and up to where we are today.
All right, thank you. In light of all the testimony presented, and I realize that you've suffered certain hardships and deaths, and I'm sorry, and it seems that you've been acting in good faith, though there was a substantial period of violation. I am going to, the correct amount was, yes, the correct
He
amount.
corrected it.
Okay. Got it. The correct amount of the fine, even considering the abatement by the town's local legislative body for a period, is $11,650. So I'm going to just, for the record, enter a supplemental order recognizing that based on the testimony and the hardships and the town recommendation, I'm going to abate the fine, that is, reduce it a very substantial amount to $1,165. And normally, when we do an order of abatement, the payment must be made within 30 days. Is there a different period here? 10 days, or just tell me.
I was gonna recommend 30 days, but if the property owner needs more time, I won't be objected to that.
I'm going to take care of it this week.
Is 30 days acceptable?
Sure. Yes.
All right. All right. So what I want you to understand about the 30 days or the 15 or whatever it was is that if you don't pay within that time, the fine goes back to the original amount. That's just standard in these orders, okay? So you have to pay that amount. Please do so on a timely basis so you can avoid any further entanglements with this matter. So I've entered a separate order of abatement, abating the fine to $1,165 to be paid within 30 days. So if you want to wait a minute, you can
Well,
get.
they have other matters
Oh, you
that
have
are going to
other
be presented. They have 3 cases that
Okay.
are
So
for
let's-
abatement.
3, all right. All right, what is the next case that they have?
$45.90, page 5, 12.3.
4590?
Yes.
Right.
We're going to confirm a fine and abate a fine.
Okay.
Chief Code Enforcement Officer Jocelyn Ramirez, property owner JNUV LLC, property address 1730 Southwest 30th Avenue, Pembroke Park. This matter is here for hearing to confirm fine and to abate fine. The notice of violation was given on September 17, 2019, for installation of windows without a permit. This matter has been complied as of December 30, 20. The confirmation of fine hearing notice and the abatement notice were sent out certified mail October 1st, 2021, and posted to the property on October 4th, 2021. The fine accrued for 278 days at a per diem of $100 from March 27, 20 to December 30, 20, and accumulated of an amount of $27,800. The Town Commission suspended the fines from March 26, 20 to June 10, 20 at a per diem of $100 for 76 days. That would reduce the fine for $7,600, and the property owner paid the $100 admin fee. So the total amount, with the reduction of the suspension of fines and the admin fee, is $20,200.
Okay.
It is the town's recommendation to reduce this fine by 90%. That would be a total of $2,020.
Your Majesty, we accept it.
Okay. To move things along based on the evidence of record and the testimony of the Chief Code Enforcement Officer and the acknowledgement of the respondents, representatives who are here, I am entering, 1, a supplemental order on the code enforcement lien, providing that the fine is $20,200. Again, this needs to be notarized. I really don't, confer with town council, but I don't know why there's a notarization requirement here, but there it is. And then I am, based on the recommendation of the town and the acceptance by the respondent, abating that order to $2,020. Is 30 days acceptable for payment?
Yeah. Yes, Your Honor.
So payment within 30 days. Again, remember, if you do not pay within that time, that actually there's notarization on both orders. So please remain so you can get a copy of all your orders for the cases.
I believe we have 3 more cases.
You have 2 more cases. There were 3 cases that were consolidated, which is 4940, 4941, 4942, and then you have case 4947.
You may want to stay up here. Viable.
Okay. The following case is for an abatement of fine. It's on page 6, 13.3.
13.3?
Yep.
Hang on a minute. Go ahead.
Okay. Chief Code Enforcement Officer Jocelyn Ramirez, case 4940, 4941, 4942 that have been consolidated. Property owner JNUV LLC, property address 1730 Southwest 30th Avenue, Pembroke Park, Florida. A notice of violation was given on January 5th, 2017. The violation was for no business tax receipt for a former tenant, prohibited sign, and unpermitted racks installation. All these matters have been complied as of December 3rd, 2018. A notice of hearing to abate the fine was sent out certified mail on October 1st, 21, and posted to the property on October 4th, 21. Okay.
Yeah, go ahead.
The fines run from June 19, 2017 to December 3rd, 2018, a total of 532 days at a per diem of $50, which accumulated to $26,600. The property owner did make a payment of the $100 admin fee. So the total to confirm is $26,600. It is the town's recommendation to reduce the fine by 90%. The total amount is $2,660.
Is there anything else?
Not at this time. I'm recommending 30 days, but if the property owner needs more time.
We fine with the time, you magistrate?
Okay, you accept the recommendation?
Yes, Your Honor.
Okay, based on the testimony and the acceptance and the recommendation, I am going to abate the fine on case 4940, consolidated with 4941 and 4942 to $2,660, payable as the others within 30 days. Order of abatement being entered now so provides that the fine is abated, again, to $2,660, payable within 30 days. Again, if not, it reverts to the original fine amount. That's standard, so you note that, right? Okay. Have another case here, I believe it's,
4947.
what number is that?
Section 13.4, case 4947. page 6.
13.4.
Okay. Chief Code Enforcement Officer Jocelyn Ramirez, case 4947, property owner JNUV LLC, property address 1730 Southwest 30th Avenue, Pembroke Park, Florida. This matter is here today for an abatement of fine. There was a violation given on June 14, 2017, for a repeat NOV, the related cases we just discussed. The violation.
Was a repeat
Yes.
violation, okay.
Yeah. The violation was for no building permit for a garage door. This came into compliance as of September 13, 2021. A notice of hearing to abate fine was sent out October 1st, 2021 by certified mail and posted to the property on October 4th, 2021. Okay. The fines accrued from August 21, 2017 to September 13, 2021 at a per diem fine of $100, a total of 1,484 days. The amount accrued to $148,400. With in addition, there was a levy fine of $250 and an administration fee of $100. It was the town's motion to cancel the fines from March 18, 20 to June 10, 20, a total of 84 days at a per diem fine of $100, which reduces the fine of $8,400. So the total amount that accrued with the levy fine and admin fee is $140,350, and that's with the reduction of $8,400. So that's the fine we're confirming, $140,350.
Here, I simply have an order of abatement.
Okay. So I'm sure it was already, let me see.
It must have been confirmed otherwise, you know.
Yeah, I'm sorry. It was already confirmed.
And what is the recommended?
It's the town's recommendation to reduce this fine by 90%. So it would be a total of $15,190.
Is there anything else right now?
No.
The respondent agree?
Yeah, I can talk. I can talk now. Can I just say one thing?
You
No, I
can-
appreciate everybody's help here, but it was, they knew, and this is what I'm learning now, is that when people know you're in trouble, and I was in Texas at MD Anderson, I had hired a lot of contractors, and they just took my money and they took off. And so I think I just learned that you never tell anybody your situation, because in South Florida, I've been abused by contractors, and I've been ripped off by the tenants I gave the rent to. And so, no, I appreciate you helping me, everybody.
No, it's you know, I look at you, all strike me as honest, well-intentioned owners, and, you know, if it was up to me, I might even abate further. However, I want you to be mindful that a 90% abatement is exceedingly generous.
I know, I appreciate
Normal
it.
abatements are half,
I know.
50% is the standard. So I think that, you know, the town is really, in my view, I accept the town's recommendation. And I think that you really, within the realm of possibility, I understand the hardship, but there's also the side of violations and the period of the accruing penalty. So you,
I appreciate it.
I can't just forget that.
If I may say, Joseph Trudeau with VLC1. Part of this this violation that was, this is for a garage door, simply. And again, this is 2017, which was with the previous engineer that passed away. I firmly believe that if this violation was standing on its own, it would have been taken care of a lot sooner than that. But because we were instructed to compile all of the violations with the, for example, with the windows that were previously installed, with this garage door, with the racks that were installed by the tenants, with the damages to the side of the building, we were instructed by the building official at that time to compile everything together. I firmly believe that if they had received that violation as a standalone violation, it would have been taken care of a lot sooner. So I think we would ask for that to be considered when looking at this case, why it took so long. It didn't take so long because they were not dealing with it. It took so long because simply they were dealing with everything together, all personal matters aside. If we even leave that out.
No, I understand, but it was, as I understood what you're saying, and again, I appreciate your candor because everybody here is under oath, and I believe that everybody has veracity. It was a recommendation or a suggestion of the building official. I don't think you had to do it. You could have just said you were going to handle that violation separately. So
With the garage door?
So the garage door was supposed, if you're looking at accordions at the time, the garage door was supposed to be together with the 40-year certification, and it was separated, and that's why it wasn't addressed. It was just something that accumulate more money to, as a penalty. And they didn't let us know that we're supposed to work with that. Because actually, the violation was done by the tenant who was there, not by.
Right, but the fact that it was a tenant doesn't matter. The owner's responsible.
There was much discussion at the very beginning. We went back and forth with the building official at the very beginning with how to do this, and that's why we took this route that we did. It was because that was the understanding that we had then, with multiple discussions with the building official and
Well, I'm not here to second guess him. All I can tell you is that I think that 90% is exceedingly generous, and I
Thank you,
think that
I appreciate it.
Your Majesty, we're gonna take the offer that you guys give us.
Thank you.
all right.
I wish we could take half of it and donate to a nonprofit organization of your choice, but it is what it is.
No, I understand. I'm abating this violation to 15,190, and please pay within 30 days, as in the others, so you can get all this behind you. I appreciate you working with the town. I appreciate your good faith, and I am sorry about your hardships, and I can only hope that you have better days ahead, and but I think in light of your hardships and in light of your difficulties, that I really do think it is my opinion that the town's recommendations have been more than fair.
Thank you.
Thank you. And now, if you want to remain, you can get a copy of all these orders. If you wish. Yes. So if you want to just remain a moment, you can get a copy of all the orders. Thank you for coming in, and thank you for taking the time.
Mr. Magistrate, can we proceed?
Yes, you can proceed.
Next on the list is case 5304.
What number is that on the agenda?
We'll tell you in a second. That would be page 3, section 8.5.
Excuse me, can you repeat the case number?
5304. Chief Code Enforcement Officer Jocelyn Ramirez, case 5304, property owner Gary Pegat, property address 3407 Southwest 52nd Avenue, Pembroke Park, Florida. A notice violation was given on August 3rd, 2020 by regular mail. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on September 30, 2021, and posted to the property on October 4, 2021. The violations were for demolition of old fence and installation of new fence without a permit, the lack of maintenance of the exterior roof and balcony. At this current time, the property owner has not complied, and I am recommending that the property owner comply in 30 days, if not a $50 per diem and a $100 admin fee.
Is there anything else you wish to add at this time?
No.
Sir, name, business address, relationship to the property, and tell us what you want to say.
Gary Pickett, 3407 Southwest 52nd Avenue, owner. First and foremost, I applaud the code enforcers for doing what you do, especially trying to keep up with the various things. Regarding the fence, I got this notification actually when it was certified mail. I am not physically here 75% of the time. I earn my living out of state most times. But as soon as I got the notification in the mail, it's funny, yesterday the pressure wash was done to the property. So chances are code officer has not seen it current, so that part was done. The first one on the fence, I paid the installer an extra, I think it was $300 or $350. So I'm following up with him regarding the building permit, because the job included pulling a permit based on my invoice. So I'm following up with them also. In the meantime, the 30 days will expire on the 29th, I think it is, and I'm requesting an extra 30 days to sort through the matters.
I don't object. 60 days, fine.
What else?
Maybe that's enough.
That's it.
All right. You're going to have, based on the town recommendation, because these don't sound like complex violations to me, but based on the town's recommendation, you're going to have 60 days to comply. If not, there will be a daily fine of $50 per day, per diem, and there is the $100 administrative fee imposed today, as there is for every case that comes before us. That's what the order provides. If you want to remain a moment, you can get a copy of it. And I thank you so much for coming in.
Yeah, thanks. I just wanted to ask, before I go, we're a homeowners association, so each unit is pretty much governed by the homeowners association in the sense of pressure washing, painting, maintenance. I'm of the opinion the property, when it was first built, whatever that code is that was set up, is assuming we're a business, because each unit is getting these types of code enforcement notices when we're a complete complex. And I'm on the board, and we're supposed to we have annual meetings and budgets. Currently, we're looking at painting the facility again next year. So what's the procedure for us to verify or go about checking to see what was set up? Because looking at one of the persons earlier, it says 7, but the physical building is 6. So in our case, we may have a similar situation at Holly Tree, where it's not coded correctly. So we would need some guidance on that to verify what is our specific code in the Broward County system, because I'm one of 40 unit owners, and there's over 5 of us that have received in the past year such notification. Fence, I accept full responsibility.
Every property owner is responsible for their unit. Now, as far as what the association covers, that is something that the property owner will have to address with the association. So let's say with the maintenance, you said that the association takes care of that. You will have to reach out to them and tell them, hey, what's going on? You gotta, do the maintenance because I'm receiving a violation. But we don't get involved in that civil matter. The violation is on the unit itself.
Okay.
And it's the property owner's
No,
responsibility.
that I understand, but it's all right. We'll have to go.
But if you want to have a more thorough conversation, you can contact me.
All righty. I'm gonna sit in for the other matter. Thank you.
Okay, we can proceed to the other cases, or
As far as I'm concerned, yes.
did he receive a copy of his order?
No, I mean, again, as far as I'm concerned, then that's the town, I've announced various times that if they want to remain, they can get a copy of the order, but if for whatever reason they don't, the town has to mail it, that's all.
No, he's here.
Right,
so.
okay, well then, go ahead, I mean, I'm the
I'm just
deliverer here.
asking, I'm just
Right,
asking.
okay, so I don't know what else you want me to do.
Okay, we can proceed to case 6240.
Thank you.
Chief Code Enforcement Officer Jocelyn Ramirez.
What is the agenda number, please, and the page?
Oh, right. That's page 3, and that's section 8.8.
Thank you.
Property owner, Holly Tree Patio Villas. Homeowners, care of USA Management. There is no actual address, but the Broward County Property Appraiser has it as Southwest 52nd Avenue, Pembroke Park, Florida. This is a violation that was given to the association on June 23rd, 2020, as a courtesy notice sent out by regular mail. Notice violation on August 31st, 2021, sent out by a notice of violation sent out by regular mail. A notice of formal hearing with a copy of the violation was sent out by certified mail on September 30, 2021, and posted to the property on October 4, 2021. The violations are for exterior maintenance of walls by pool area, exterior maintenance of roof, exterior maintenance of mailbox, exterior maintenance of common areas, sidewalks, such as sidewalks, and exterior maintenance of monument sign. At this current time, the property is not in compliance, and I am recommending that it be completed within 30 days, if not a $50 per diem and a $100 admin fee.
Is there anything else you wish to say at this time?
No.
Sir, name, address, relationship to the property, and tell us what you wish to say.
Yes, Your Honor. My name is Paul Shapiro, USA Management, 9000 Sheridan Street, Unit 166, Pembroke Pines, Florida. A few things that I'd like to address. I've notified the city of Pembroke Park numerous times by telephone and email of the address where notices are supposed to be sent. They continue to send it to our old address where we haven't been there for 3 years.
Well, let me interject if I may. The town, because this comes up very occasionally, the town is supposed to by law give notices to the address you have on file with the county. So if you have not changed, if you've changed that address with the county, you have every argument to make here about that. But if you have not, and it was sent to the address you have on file per the county, again, you can advise the city till the cows come home, and that's fine. But I'm telling you, what the law requires is that they send the address to where you have it on file with the county.
I understand that. Can you pull up, I have my reading glasses on, so I can't see too far, but if you pull up Sunbiz, what is it, the address?
I'd like to explain to Mr. Shapiro as well
Yes,
that we
please.
have told him multiple times that he has to correct that address on Broward County Property Appraiser.
Broward Property County Appraiser, I see it has a site address and it has a mailing address.
It was sent out to them.
So it was sent out to those addresses.
Mhm.
Well, then the town did all that it was required to do. And Sunbiz, they don't go by Sunbiz. Sunbiz is the same, Sunbiz is a different address, okay? But they don't go, the law doesn't say they go by Sunbiz. The law says they go by the Broward County Property Appraiser, to be clear.
Okay, so we have to notify the Broward County Property Appraiser as a change of address.
Yes, you should call that office, ask if they have a form for that or whatever it is, and do that.
Okay. So we'll take care of that. We received this notice because it went to our old address, and it was dated September 27th. We received it last week. The notification says that we have 30 days to comply, but I just want to verify what the violations are. The exterior maintenance of the walls of the pool house and the roof of the pool house. Am I correct in that?
Correct.
Okay, so that has to be pressure cleaned. The exterior maintenance of the mailboxes, pressure clean. Exterior maintenance of common area sidewalks, pressure clean. And
Well, as you can see in the comments, it says pressure wash, treatment, repair, paint. So I cannot tell you. It just has to look in good condition. So if it requires paint, requires anything else, please do so.
right.
So
But
the goal is for everything to look in a good appearance.
correct. But the sidewalks are not painted, but they do need to be pressure cleaned.
Correct.
Okay. The exterior sign, I believe it was 2 years ago, a new sign was installed on the property. And from what I understand, someone had written graffiti on the sign.
Right.
The president of the association removed as much as possible.
Okay.
Have you inspected the sign?
Yes, but it's still faded. I don't know if somebody just needs to paint over it for the sign to be completely remove the graffiti.
So we have to touch up the sign.
Touch it up.
Okay. The last thing is that we had 30 days to become compliant from the date of the letter, which was September 27th, so we have until October 27th to be in compliance.
Right now, I'm recommending 30 days. You will get an additional 30 days.
That would be wonderful if we could get 60 days, because we have to get this approved by the Board of Directors and proceed.
So we'll give you 60 days.
That would be great.
All right. I hope we've clarified to your satisfaction what it is you need to do, because the town has agreed, because they don't seem like serious violations to me, but the town has agreed to 60 days. So you'll have 60 days from today's date to comply. And if not, the daily fine is $50 per day. And there is a standard administrative fee of $100 for each case. That's what the order provides. If you want to remain a moment, you can get a copy of it. And,
Your Honor, I'd like to ask a public question to the code enforcers.
well, you can ask. They're not here on trial, so they don't have to answer if they don't want to. And you can ask it privately, but you can try to ask. Sure.
No, my thing is that we're asked to do these paintings, okay, from a code enforcer position.
Yes.
But who's the code enforcer we need to speak to as residents regarding painting the rusted wall out front of City Hall? Okay? Because it's becoming strange that we owners are being pushed to that side.
Right.
Okay? So that's why I'm bringing this up publicly, so it can be recorded. Thank you.
Thank you. Just to let you know, the notice of violation has been written to the town of Pembroke Park to take care of that.
Well, it's over 3 years, so congratulations. Appreciate it.
Mr. Suarez, can we proceed?
Yes, yes.
Case 5676.
What agenda number is it?
It is on page 5 of the agenda, 10.1. For a hearing to abate fine.
Okay, you may proceed.
Officer Teresa Malcolm for Town of Pembroke Park, Florida. Property site address is 5409 Southwest 41st Street in Pembroke Park, Florida, 33023. Property owners are Irene Quitney and Miller Schwarzreich. This violation was originally on March 23rd, 2021. A notice of violation was written for a permit, a AC that was installed without permit. Also for the patio slab that needed repairs and for the prohibited outdoor stored items in the backyard. Notice of violation with a formal hearing was then set for July 20th, 2021. A final order was entered into the record on July 20th, 2021. A notice for formal hearing for abatement of fine was then mailed out and posted to the property on 9/28. On 9/30/2021, the property became into compliance, so we went ahead and put an affidavit of compliance. I received a text message as well as a phone call from Ms. Miller Schwarzreich, who's here present for this case, for a hearing for abatement of fine. At that time, the fines accrued to $2,250. The town's recommendation is to go ahead and reduce it by 90%. For the owners to go ahead and pay the $100 admin fee plus the $225 within 30 days.
Can you tell me what that amount is?
The total was $2,250.
Right. What is the abatement amount that is being recommended?
A reduction of 90%.
What is it?
So $225.
But you mentioned some other figures.
The administrative fee
Okay.
of $100.
Which is unpaid, the administrative.
Correct.
Okay, so we're talking about $325.
Correct.
Is there anything else you wish to add at this time?
No.
And you're recommending payment within 30 days?
Yes, if the owners have no objection.
Okay. Ma'am, let's hear from you and state your name, your address, and what you wish to say, please.
Good morning. My name is Mila Schwarzreich. My address is 150 Swan Avenue in the city of Plantation. I am an owner of the property along with my mother, Irene Quitney, who's present as well. When this violation was first received in March of this year, we were in contact with Ms. Malcolm within days. She has been extremely helpful and very easy to work with. Sometimes I think I called her too often, but she was always very kind, thoughtful, and considerate. I'd like to point out a few things with respect to the actual fine. First, the issues to be corrected were some backyard debris. That was corrected within days. It was a tenant-occupied property. We notified the tenant, and the tenant did, in fact, correct by removing all the debris from the backyard within days of the March notice. The other violation was the patio slab concrete that should have been an association correction because it is a HOA. We, however, did not want to wait, so we had that corrected at our own expense, also way before July, the 20th hearing date. With respect to the hearing date, and I think if you scroll back to those notices, they were never received. And I know you've indicated several times we're all here under oath. I'm an attorney. I've been practicing for over 20 years. I don't miss hearings. So if there was a hearing, I can assure you I would have been here. And the only reason we weren't here was because we were not notified. So the only thing outstanding was getting a permit for the AC unit that was repaired that was actually a brand new unit, was put in a number of years ago. That too, we began working with the AC contractor. He had some personal issues. His father was diagnosed with brain cancer. It took a little bit longer than we had hoped. That wasn't a delay because of our acting in bad faith or our not being diligent. And we really continued to be in contact with Ms. Malcolm throughout the process. Finally, he was able to get the association, because since it's an association property, even applying for the permit wasn't easy. The association had to prepare and provide documents to us and then to him in order for him to submit to the town. He finally was able to get those documents. That was done. I mean, it sounds simple, but the process and the red tape from a variety of folks was not easy. That was finished and approved, I believe September the 13th is when the town issued the permits. We notified Ms. Malcolm shortly thereafter. She was, very, again, thoughtful, easy to work with. I'll back up a little bit. And we moved forward in that way. So had we had the opportunity to be here July 20th, I would have asked for the time that has been given to everybody who has appeared here in order to become compliant. I think we've shown our efforts in becoming compliant and resolving what we can as expeditiously as possible. So I would ask, since we were not notified of the July 20th hearing, that the fine be completely abated. I see lots of the abatements that come before you for things that, in this case, would be viewed as minor. None of the fines are $100 a day for something minor. I think that's excessive. And if we were here on the 20th of July, which, again, we would have had we been notified, we would have been giving an appropriate time frame given all of our steps to correct the issue, to become compliant. So I ask that we get a complete abatement.
I've listened to you. I'm mindful of everything you've said. Let me ask this of the town, and thank you. Thank you for speaking and for appearing and for being, explanatory about all this. As to the original hearing, Ms. Malcolm, as to the original hearing, the main thing that I've heard that has been of any interest to me has been the address. For the original hearing that, she is talking about, that she claims that were not noticed, was that notice given to the correct address of record?
Yes, it is. Yes, the correct address were given, but I can attest that when we received the green cards back, it did not have a signature, and that's a conversation she and I had, so I'm aware of that. So whether, I'm not sure if when it got delivered, well, we received one notice back on the 22nd of July and one on the 27th of July. But again, there's no signature of who signed off for it, nor does it says COVID-19 for the Postal Service. We just received it back.
But it is the correct.
But it is the correct addresses that we do have on file.
And was there any other kind of notice given of the violation at that time?
No.
So, Special Magistrate, I would submit that the failure of proper notification would then give us an opportunity to abate anything that happened, especially the fine implications that were issued July 20th. As I indicated, we did not get notice, and there's nothing on that return receipt that reflects that that item of mail was received by anybody, much less us. So I don't think it complies with the notice requirement of the statute.
The notice was sent by certified mail to the correct address, but it wasn't posted as well.
It was posted to the property as well.
Okay, that's why I just asked you that. I said, had there been any other kind of notice? I'm sorry, you misunderstood, but.
Yes, it was posted to the property as well for the July's hearing as well as for today's hearing.
Okay, so it was posted to the correct property?
Yes.
And the notice was?
It was certified mailed out.
Certified mail, but unclaimed?
Correct.
Okay, in light of everything that has been said.
Well, keep in mind, it's a tenant-occupied property, Special Magistrate. We don't live there.
Right, but that's not the town's fault, and that's not required by Chapter 162, that the tenants be notified, or that they tell you, or that if they're responsible. Listen, I've heard everything you've said, and I do have an open mind, but I do think that the town's recommendation is, again, generous. In my experience, 90% is a very, very substantial reduction. And, you know, for your information, you may term the unpermitted work minor. It's very debatable that it is minor, but even if it is minor, again, just for the record, many other towns have per diems that are 100, 150, and 250 per day. So I think they're quite reasonable here. So I am going to accept the city recommendation. I am going to abate the fine to $325.
Mr.
No, go ahead. Continue.
I'm going to provide for payment as been standard unless you advise otherwise within 30 days. And I am sorry about this. I am sorry about the, annoyance and the discomfort it is created. But again, I do think that in light of the circumstances, the amount is more than reasonable. And I understand your arguments, but I hope you understand what I have stated. And that is what the order so provides. And Madam Counselor, if you'd be so kind to remain a moment, you can get a copy of the order right now, and you can put this behind you very easily.
Understood. Thank you.
Thank you very much for coming in and for advising us.
Case 5833.
Okay, and what number is that on the agenda, please?
Page 4 of the agenda, number 9.3. Thank you. Code Enforcement Officer Teresa Malcolm for Pembroke Park, Florida. Property site address is 427 Marine Drive, Pembroke Park, Florida, 33009. Property owners are Janice and John Sullivan. Original notice of violation was written on May 10, 2021. Notice of formal hearing with a notice of violation was posted and certified mail on 7/30/2021. I received an email from Mr. and Mrs. Sullivan's attorney for a continuance. The case was continued for today's date, affidavit of service and posting, as well as certified mail on 9/28. The original notice of violation was for an AC changeout that was done prior of the permit issuance, which is process 93200. A new slab that was poured without permits, and also for the electrical lights that were added in the steps in the front of their home.
What steps that were?
They have some concrete steps. Mary, can you go to the picture so I can show Mr.
Oh, I see.
Yeah, okay, yeah, they have some lights in their steps, which we have no permit or records of it on file, so they need to obtain a permit for that.
So it's the lights?
Yes, correct.
And that
The electrical.
Not by, it requires an electrical permit.
Correct, yes.
Okay.
There's pictures to depict the violation. From my knowledge, the AC permit, they applied for it, but it wasn't issued at the time. So when I was driving in the town, I just stumbled on them doing the change out prior of actually having the permit on hand. So that permit has been taken care of. So the only thing that is left open on the violation is for the electrical for those lights and their steps.
What are you recommending?
My recommendation is to give the owners 90 days at a $50 per diem, since I'm aware that they recently just got back into Pembroke Park from their home in Massachusetts.
Anything else at this time?
No.
Okay, sir, you are name, address, relationship to the property. Tell us what you want to say.
My name is John Sullivan, with the property owner, my wife, at 427 Marine Drive, Pembroke Park, Florida here, Park Lake Estates. My legal address is 30 Pearson Street, Saugus, Massachusetts, 01906. Thank you. Everything went well. We had several emails back and forth with Liz Rappaport, the law firm. She responded immediately to everything. The lights there, you're probably well aware, the unit is it's a 1990 mobile home. My in-laws bought it in 93. They had passed away, and we bought it off the estate 6 years ago. I've been going down there since 1993. The lights were in there. I have some updated pictures, too, of the lights from different times, okay? So, obviously, permit, how those things work, I have no clue, from 30 years ago. And I know like Liz Rapper had several emails back and forth with you trying to locate whatever, and all the permits, carport, everything else were found. So I don't know what to tell you. Whatever has to be done, let me know. In the last 19 months with COVID, everything else, we've only been here 2 weeks, okay? And I'm leaving again I came down for this hearing from Massachusetts. We're leaving, again, I'm leaving on Friday. I'm not really sure when we're going to be back, okay, with everything going on. So just tell me what has to be done, and we'll do it.
Okay, so per the testimony of Officer Malcolm, which was clear to me, she's giving you 90 days, 3 months, to get an electrical permit for the lights that were added at some point to the front of your house, to those stairs, on the front of your
Right,
mobile,
the stairway.
You're right. And, you know, I know you're saying it's been there for a while, but if you can show a permit to me or some approval, I would dismiss the case. But if you can't, it needs to be permitted.
No, it wasn't, this is going back so far that.
So you're being given 90 days to do that. If not, there's I think it's an ample period, but if you don't comply in 3 months, it's a $50 a day fine, and there's a $100 fee for each case that comes here. That's pretty much, do you understand?
Yeah, I understand. So I guess I just have to go up to the electrical department. Do the lights have to be replaced, or somebody has to go out and inspect it after I get the permit, or?
You will have to go speak with the building department so they can further give you instructions on.
Building or electrical?
No, the building department is the same
okay.
entity.
Okay.
Mm-hmm.
Fine with me.
Do you know where that is?
In the building?
Well, you'll go outside this door in the main entrance, and you can ask the receptionist for the building department
okay.
here.
Okay.
Explain and, you know, follow their, directions as to what you need to do.
Okay.
It seems to me like 3 months is ample period of time. I'm sure you can do it, but you really shouldn't leave again and forget about it because, 3 months will pass.
Take a walk over there now.
Okay, so if you want to remain a moment, you can get a copy of this order, please.
Okay.
Thank you. Thank you for coming in.
Case 5705.
And you can just give me the agenda number. You don't need to.
Oh, sorry. Page 5 of the agenda, 11.1. For hearing of extended time.
Go ahead.
Code Officer Teresa Malcolm for Town of Pembroke Park, Florida. Property site address is 3140 West Hollandale Beach Boulevard. West Hollandale Beach Boulevard, Lot 423. Property owners are Eduardo Saranova and Jessica Garabajar. Original notice of violation was written on March 29, 2021. Notice of formal hearing was with the posting to the property certified mail was on June 29, 2021. A final order was entered into the record on July 20th, 2021. I received an email from the property owner, Mrs. Jessica, for extension of time. So the formal hearing for extension of time was then certified mail as well as posted to the property on 9/28/2021. The original violations were for the unpermitted concrete slab at the rear of the property with the sidewalk of the mobile home, the unpermitted addition at the side of the mobile home, unpermitted replacement of multiple doors on the mobile home, an unpermitted shed in the addition area, as well as for prohibited storage on the property. Windows were painted, which needed to be unpainted for a safety hazard. At the day of reinspection, as well as posting on October 1st, I met with Miss Jessica at the door, posting to her property, and she explained to me that she was having a lot of financial restraints, as well as having a sick child that needed a lot of health issues that is preventing her from continuing to go ahead and obtain the rest of the permits, as well as finding an engineer for her addition. The only thing that she went ahead and obtained was for the permit for the sidewalk or slab area at the side of her home. And she's here. So my recommendation for extension of time for her is to give her an additional 90 days as a final extension with a $50 per diem.
Thank you. Please, for the record, your name, your address, and please tell us what you want to say.
Yes, my name is Jessica Carabajal. My address is 3140 Hallandale Beach Boulevard, Unit 423, Pembroke Park. So yes, I'm here for ask for the extension. So I tried to contact to the engineer and what is the other?
The architect.
And the architect was very hard for me. So some of them never answer, and who answered say no, I can help you. When finally I find one, his name is Eliezer Diaz. So he went to my property and he said yes, he can help me. He came here to the city to speak with the office. Well, he has to charge me $20,000 to fix that. So I want to keep my mobile home because it's my home. I live there with my 2 kids. So I'm the only one working home. So I think I need a little bit more time to see if I can get the money to fix that. If not, I will have to remove the addition.
Yes, and so there's no confusion, when you remove the addition, you'll need a permit for that
Yes,
as well.
sir. Yes.
So, because I don't want you to, all right, I think in light of all the testimony and the evidence, I'm going to provide the additional 90 days. If not, there will be a $50 per diem or per day fine, and of course, the $100 fee. And I understand your circumstances, I'm mindful of them. I want you to understand that on the other side of the coin, with code compliance, the idea is compliance, but it can't go on, and I don't mean to sound harsh, but I just want you to try to appreciate this. It can't just go on in perpetuity. There has to be a resolution at some point, or we would be in an endless circle here. So this is an extension now. Just so you know, I would not be inclined to entertain any further extensions, because, there's already been a time, and this is an additional time. So am I clear as to what I'm saying?
Yes, sir.
All right. Please remain and get a copy of the order, please.
Yes, thank you very much.
Page 6, section 13.5.
13.5.
Chief Code Enforcement Officer Jocelyn Ramirez, case 5468. Property owner Carlos and Maureen Brown. Property address 3475 Southwest 52nd Avenue, Unit 38, Pembroke Park, Florida. This matter is here today for a confirmation of fine and an abatement of fine. A violation was given on December 2nd, 2020, for pouring concrete to form a slab on patio area without a permit and installing an unpermitted shed. The property is in compliance as of August 4, 21. The fine accrued for 33 days from July 2nd, 21 to August 4th, 21 at a per diem of $50, which accrued $1,650. As of now, the property owner did pay the administration fee, so the total amount to confirm is $1,650.
Okay, I have 1,750. Just for the sake of clarity and to avoid
Yes.
needless complications, I'll just manually correct it
Okay.
in the order, okay? Because again, I have 1,750.
Correct. And it is the town's motion to reduce this fine by 90%, so it will be a total of $165.
Is there anything further that you wish to say?
No.
Can we hear from the respondents? Are they in agreement? Please give your name, your address, and anything you wish to say.
My name is Rahima Golding. My address is 98 Southeast 1st Street, and I am here with the property owner, Miss Maureen Brown.
Yes. All right, I am going to enter an order. One, a supplemental order finding that the correct amount of the fine is $1,650. I'm going to enter a further order abating or reducing the fine by 90% to $165.
Okay, thank you.
The amount has to be paid, again, I try to treat things uniformly unless there's a different reason to, within 30 days. What I want you to understand, if you've been hearing other cases like this, if you do not pay within that period of time, the fine will revert to the original amount. And at least I would not reduce it again.
Right, and if I may add, this violation would have been abated long before, but because they obtained the first permit, which was for the concrete slab, but the shed would have required them to get structural and engineer drawings.
Yes.
And that would have taken a lot more time and money, of course. And
Yes.
they didn't retain me until June 30th. And it was with my knowledge and expertise in the building field
Yes.
that they just demolish it. So by the time they had retained me, we only had 15 days to obtain the permit and get the final inspection. So we would not have been able to do it sooner than that.
No, and I appreciate your explanation, but along with other factors that we've discussed here in code enforcement, there's also timing. So I regret that you were retained late in the game, because it seems you've been advising them, wisely, but these are the facts we have before. So I think that the 90% reduction, again, is generous, and that's what the order will provide. please just pay it within the month, and so you can avoid the original fine. And if you want to remain a moment, you can get a copy of the order.
I appreciate that. Thank you.
Thank you.
Okay. 53. Let me get the page for you. Page 3, section 8.6.
8.6. Go ahead.
Chief Code Enforcement Officer Jocelyn Ramirez, case 5316, property owner Carmen Rodriguez, property address 108 Lone Pine Drive, Pembroke Park, Florida. A notice of violation was given on August 13, 2020 by regular mail. A notice for formal hearing and a copy of the notice of violation was sent out by certified mail on September 30, 2021, and posted to the property on October 4, 2021. The violations were for installation of a carport without a permit, installation of new central AC unit without a permit, installation of shed without a permit, and outdoor electrical done without a permit. At this current time, the owner has not obtained any of the permits, and I am recommending for the owner to comply within 60 days, if not a $50 per diem with a $100 admin fee.
Is there anything else you want to add at this time?
No.
Name, your address, and what you want to tell us, please.
Sure. Good morning. My name is Carmen Rodriguez, 108 Lone Pine Drive on Hallandale, Florida, 33009. Yes, when I purchased, actually I'm like a snowbird. I don't live there permanent. I live in New Jersey, and comes there once in a while. When I purchased the motorhome was already as it is. The only thing was not there, it was the shed. I mean the carpool, I'm sorry. And ready, we have everything, our hire contractor in Fresco Corp. We already have everything ready. We just need the permits, and the carpool will be on demolition. I told them already, I don't want it. If I can get the permit to demolition, the carpool.
Right, you need a permit for, for the demolition. You know that, right?
Yes. Honestly, I didn't know because I'm from Jersey. I don't stay here that often. That I need a permit for the carpool. I learned my lesson. Now I know. So I just want to demolish it and get it over with, and do the right thing. So I have all the paperwork with Impresso Corp, who's working on with me to get all the other things done correctly.
And they have said they will get the permit for the demolition.
Correct. Definitely, they will get the permit. I'll make sure.
As for the other things that you heard besides a carport, what are you doing about that?
Also, as well. It's the shed and some other things. That will be taken care of also by the Impreco Corporation.
Right, and you realize that even if those things were there when you bought it, if they're not permitted, you're still, whenever they're cited, it's the owner's responsible.
I know, Your Honor. I didn't know that. You know, I just purchased. I don't stay there. I just come in. For matter of fact, I just came from Jersey last night for this day, and so I was not aware. But now I am aware.
Okay, so you're going to be given 60 days, 2 months.
Thank you, sir.
All right?
We're going to do it as soon as possible. I don't want to wait.
Correct, that's right. Well, you have up to 60 days, but no more, 60 days.
No, definitely.
And, you know, I always listen to the town's recommendation because I am not inclined to want to be, you know, enlarging and modifying. I'd rather just get the dates correct the first time. So if not, there will be a $50 per diem fine. And There's the $100 fee for each case, which is imposed as well. So, but you need to have this work done within that time. And if not, you'll have to deal with that fine. So please do it within 2
Sure.
months. And if you remain a moment, you can get a copy of the order, okay?
Thank you so much, appreciate it.
La siguiente es, we have to hear from them. What's the next case?
5709.
Where's that on the agenda?
11.2.
Right, you've got to point out the agenda number, please, because since we go hopscotching throughout, I need to know the agenda number. Thank you.
5709.
Yes, thank you.
Code Officer Teresa Malcolm for Town of Pembroke Park, Florida. Site address is 3181 West Hollandale Beach Boulevard, Pembroke Park, Florida, 33009. Property owners are Devco LLC. Notice of violation was written originally on March 30th, 2021. Notice for formal hearing with a copy of the notice of violation was certified mail as well as posted to the property on 7/29/2021. A final order was entered into the record on August 19, 2021. I received an email from Mr. Doug Driver for a hearing for extension of time. So the hearing was set up for formal hearing for extension of time. It was posted to the property as well, mail certified on 9/28/2021. Original notice of violation was extensive. It's for the following items. Property needs to be maintained, pressure washed and painted, multiple doors, steps have been cracked with concrete at the entrance of the doors of each unit. Arrested and wood damaged wall unit on the third floor laundry room, which needs to be replaced and or repaired. Unit 105, installed a camera system around the property, as well added a fence to divide the backyard. To also remove the hurricane shutters from the property, the patio area. Other tenants had camera systems installed, which a low voltage permit is required for those installations. Multiple light shades, bases missing on light fixtures. Multiple areas of the balconies needed concrete repairs, as well as the floodlights on the roof edges needed concrete repair, which needed a permit. A screen door was replaced on the first floor with the balcony area, which needed permits for those, as well as the screens on the balcony areas in the back needs to be replaced with new screens. Property, number 9 was completely removed from this violation because it was adjourning properties violation, so a separate notice of violation was then made for that. The chain link fence needed repairs facing West Hollandale Beach Boulevard. The parking lot had a lot of potholes which needed to be repaired and repaved. Also, the parking lot stripes were faded, including the parking stumps which needed repairs. There was abandoned vehicles on the property, which that item has been complied with. There was a gap facing in the front of West Hollandale Beach that should have hedges. So that is still not cured as of yet. I met with Douglas Driver for property management. He got hired by the property manager to go ahead and take care of all of these violations. And since meeting with him, he's been very helpful. He provided me with a spreadsheet with the steps to get they have a total of 4 cases that are open. So he provided me with a spreadsheet, and I meet with him maybe once or twice a month to go ahead and give me an update of where they stand. He requested for an extension for this case as well as another case. My recommendation is to go ahead and give him, since he already had a 30-day extension, is to go ahead and give him 90 days to go ahead and comply with the case, with it, since it is a bit extensive for this case as well as the next
Additional
case.
90 days.
Yes.
Anything else at this time?
Also, I wanted to add that on Friday, October 15, I received an email copying the building manager in the building department that he went ahead and submitted 5 electrical permit applications into the city. So he is doing due diligence by working with myself as well as the building department to go ahead and comply with the rest of the violations.
Very well.
Douglas is here.
Okay, name, address, and please tell us what you want to say.
My name is Douglas Driver. My company is Meridian Commercial. We're commercial real estate consultants. We represent the owner. Address is 10101 West Sample Road, Suite 428, Coral Springs, Florida 33065. Appreciate the city working with us. You know, we're trying to do everything we can. We've submitted permits. We've actually, of the 15 items that we've been over, 6 of those have been remedied at this point. We've pulled permits for the other items that are on there, except for the hedges, which doesn't require a permit. But given the process we have to go through, we have to do painting first, stucco, then we can do fencing, and then we can do striping, and then we can put up the hedges. So those have to be done in a certain order. If not, they all get trampled on. So it'll take us that long to get it done. And again, we're doing everything we can. We've got 25 different violations here. Right now, we pulled permits, I think, for all of them, except for one, which is the air conditioning permit, which we just finally found equipment for, and we'll probably be submitting that this week.
Okay, does the, I am mindful of what the town recommends, so I'll make my own determination, but I think in light of everything I've heard, the 90 days sounds reasonable to me. Is that acceptable?
Yes, sir.
Okay, I'm going to enter an amended final order in this matter to provide that for the outstanding items, the, half of the violations that you heard that have not been addressed, you have to comply within 90 days. Not the per diem that you recommended?
It was, we're going to keep the same per diem at $500.
So I know that I'm sure that was due to the multiple nature of the violations. So there is an administrative fee today, as there is in every code compliance case that comes here, or in any city, of $100. But the fine will only commence if on the 91st day you have not reached compliance or correction. And then it's 500. And that's what the amended final order provides. If you want to remain, you can get a copy of it. And if you have another case, which I'm sure we're going to hear now, you may as well just get copies of both of you, right? And that case is number what on the agenda?
11.3. 6001.
6001. Hang on a minute. Okay.
Officer Teresa Malcolm for Town of Pembroke Park, Florida. Property site address is 3180 West Hollandale Beach Boulevard, Pembroke Park, Florida 33009. Property owners are Devco LLC. Original notice of violation was written on July 2nd, 2021. Notice of formal hearing with a copy of the notice of violation was certified mail as well as posted to the property on July 30th, 2021. A final order was entered into the record on August 19, 2021. Posting to the property as well as certified mail with a notice of formal hearing for extension of time was mailed on September 28, 2021. The original notice of violations were for in Unit 306, drywall repairs that were done without a permit, to obtain plans for it, for the leaks in that unit, for the concrete restoration. And again, concluding the previous case, there's a lot of cases that they've been working on. So my recommendation for this one would be an additional 30 days with the per diem of $500 for this case particularly.
30 days on this one?
Correct.
Because it's less extensive.
Correct.
Is there anything further at this time? Sir, again, for the record, please proceed. Name and what you want to say.
My name is Doug Driver with Meridian Commercial, or Commercial Real Estate Consultants representing the owner. Our address is 10101 West Sample Road, Suite 428, Coral Springs, Florida 33065. You know, we'll accept the 30 days. We're hoping to get the Suncoast, the painting contractor, out there next week. They submitted their permit. That will take care of the concrete and the drywall repairs. I've been in there. I don't think they're going to have us do anything. I pulled the permit for it already. So I'm just waiting to call in the inspection until we have a couple of things the inspector to look at the same time, so we're not wasting your time coming out in an hour.
So 30 days seems reasonable for these particular violations there.
Yeah, I mean, as long as the painting contractor does what they're supposed to do, you know, we're supposed to get their permit back this week. It'll probably take a week or two to be able to get on their schedule, and then it's going to probably take them 3 weeks to get their work done. So 30 days, probably close, but.
Well, are you pressing them?
Yeah,
Because, you know, I want to be clear on one thing. What I like to just give a reasonable time, and again, you've heard us say compliance is the key here, and we don't want these things to go on forever. But if there's any doubt, I'd rather go for 45 or something if you think that, you know, I mean, because I don't like to keep, you know, and, you know, I think a period is a period. And
Originally 60 days, just because the painting contractor is the one that we have to get through. I mean, it's the one we really, is the time.
Action to that, 60 days.
Okay, 60 days. If not, there will be a per diem of $500. And you have the 60 days, sir. But as you heard me say, you know, this is not, you know, I'll come back and see you again. You know, this is, I don't plan to entertain further extensions, okay?
I understand.
I mean, you know, absent, you know, some extraordinary circumstance, okay? So I want to be clear on that.
No, I appreciate that.
Thank you.
Thank you.
Sorry, continue. Okay. And what is the next case? We remain a moment for the orders.
The next case is on page 5, section 12.1. Chief Code Enforcement Officer Jocelyn Ramirez. Business owner AXS Points. Address 1128 South Powerline Road, Deerfield, Florida. The violation was on property address 4900 West Hallandale Beach Boulevard, Pembroke Park, Florida. The initial violation was given on June 21st, 2019 for jack and boring, trenching, and installing cables without a permit. This matter is here today for a confirmation of fine. Notice of formal hearing to confirm fine was sent out by certified mail on September 30, 2021, and posted to the property on October 4th, 2021.
Is there anything else further?
Yes. The fine accrued from February 22nd, 20 to October 2021 at a per diem fine of $50 per day. It accrued for a total of 606 days, and the total amount is $30,300 plus the administration fee of $100. The town made a motion to cancel daily fines due to COVID-19 for 84 days from March 18, 20 to June 10, 20 at a per diem of $50, which is a reduction of $4,200. The total amount to confirm is $26,200.
Do you have anything else at this point?
No.
Thank you. And sir, name, address, and anything you wish to say.
My name is Jim Lovig. I'm with Access Points.
Our address is 1128 South Powerline Road, Deerfield Beach, Florida. And we did the work there. We weren't aware that we needed a permit at that time for private property. We did have an FDOT permit to go along on that road. She stopped us. We got the permit. And the issue is trying to close the permit out, and that's where all these fines are starting from. We did get the permit. I was here for the last hearing on March, when was this?
It was for April 13th.
Yeah, April 3rd, yeah. And the city attorney, because I was taken off of the call, she came outside and told me that because I complied with everything, that would I just pay a $100 fine, and would that be okay? And I was, of course, yeah, that would be great. So I'm waiting in the mail for the bill for $100, and now I get another summons or the thing to come here saying that the fine is still going on. And I tried to close the permit. I have emails to her, and she even emailed somebody else to try and help out to close the permit out, and I never got anything back. So for me to pay a fine, when I thought this was all over, when she said it was done, this Melissa Anderson, she even came out and signed the paper for me.
Yes, that happened because we were all under the impression that the permit had closed, but that's why I had sent Mr. Ludwig an email on June 30, 2021, explaining to him that his permit is expired. It was a system error where the system wasn't showing it, it was expired. So confirming with the building manager, and he also spoke to the building manager, his permit is expired, all the inspections were not completed.
When did his permit expire?
One moment, let me pull the permit.
And because this is a engineering permit, I tried to reopen it, and you're not allowed to do that. I have to start the process all over again.
Well, it seems that, again, I can't advise you, as to what to do. That's not within my purview. But offhand, the fine is to be certified, which means that, there was a proceeding earlier. We're not here to re-argue the whole case. Whatever misunderstanding there was, it's a matter, what, were you going to say something?
I have here in evidence that the permit is expired, but as far as the date when it expired, Teresa Malcolm is looking for the date that on the permit system.
I just thought it would be interesting to know, but, you should have known when it expired, but, because
I
you
kept trying in the system to close it out, to get the final. We did the pre-construction meeting with Miriam, I believe her name is.
Right.
And, everything was completed. And I'm trying to close it out, and it wouldn't allow me to, and now I'm getting fined for something that kind of really isn't.
Well, it seems to me, again, I can only take the cases that come here before me.
Right.
It seems to me that maybe, you could make an argument later if you move to mitigate the fine or something like that. But right now, the permit had expired. So I know that by law, under the building code, when the permit expires, you can't close it because the permit is null. It's no longer in existence. It's not valid any longer.
Well, that's why I wondered.
Right.
When Melissa told me that everything was taken care of, I thought they closed the permit out, everything was done.
Let's just again, we're not you're the person here. We don't you're the person who's testifying, but. Just going by fact and not going by hearsay, which is what you're referring to, what someone else said, did you pay the $100?
I paid, because we had to redo the permit, and it was actually double. So I paid $200 and something to to get the permit, and, no, that's $100 from her. No, I was waiting to get something in the mail.
All right, okay, all right, so, there's no, you were told that, apparently some misinformation, some misconnection, but you didn't pay the money, so.
Not that $100.
All right, so, okay, so you didn't pay that, so I feel that based on what I have before me, that the permit expired, though there's been some confusion about when it expired, but
Right.
it's clear that it's expired.
It's clear that it's
And
expired.
that's what's precluding him from closing out the permit, the fact that it's expired.
Right. And
So-
like I said, even after the conversation that you had, I sent you an email letting you know that it was expired. The emails that I sent you is attached with the building department, letting you know that it was expired. And
Right,
and the thing is that I've been in communication with you through email.
Oh, you've been great, yeah.
And really and truly, you have to keep on top of it as well. So there's two-way communication here. You need to know if your case is closed. You need to know if everything's completed.
So I think that in light of the facts and the circumstances and the expired permit and the evidence in the record, which is said has been admitted, I have no, I'm going to enter an order, supplemental order. I'm going to certify the fine at $26,200. If you want, sir, though I cannot advise you, and I am not doing so, you may later want to inquire if you can make a motion to abate or reach a settlement or something like that, but that's not here today. I mean, the fact is there was an earlier hearing and there was a violation found, and now the permit had expired, so you couldn't close the case. And I think it's appropriate for me to enter this order, which is what I've done. And I'm sorry about this, but I really, I feel like that's
Once
a
the
logical thing to
permit's
do.
reinstated and you close out the permit, everything's completed, then we can mitigate the fine. You can come back.
I did submit paperwork to reopen
Okay,
the permit.
that's
I
good.
did start that process, yes.
All right.
Right, so, but it needs to be all done before you come back here, as far as I'm concerned.
Right, well, all the work is complete. Once I.
Right, but I mean, the
It'll all be
permit-
taken care of,
The
yes.
permit, right. So if you want to remain a moment, you can get a copy of the
Sure,
order.
thank you. Thanks, Jocelyn.
Perdón.
You're welcome.
Yeah, stay there a minute then. Esta mujer está como 8 meses en más que miran por aquí y para allá.
For
the next hearing, we need to change.
I think so. Mi opinión.
No, it's true. But he needs the training for make that.
Oh, she needs the training
She
for,
needs the training for make that.
oh, okay.
Okay.
Yes, tell me the,
Page 3,
right, the matter number, I mean, the docket
Section-
number is what?
8.4. Okay. Chief Code Enforcement Officer Jocelyn Ramirez, case 5279, property owner Jermaine Dyer, property address 5403 Southwest 41st Street, Pembroke Park, Florida. A notice of violation was issued on July 23rd, 2020, and sent out by regular mail. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on September 30, 2021, and posted to the property on October 4, 2021. The violations were for an installation of a canopy, a wooden deck, a wooden fence, and a washer without permits. As of today, the washer has been removed. The wooden fence has been removed. And what is outstanding is the permit for the wooden deck and the canopy. I am recommending that this be completed within 30 days, if not a $50 per diem and a $100 admin fee.
Anything else at this time?
No.
All right, please, whoever's going to speak, give your name, your address, and what you want to say.
Jermaine Dyer, address 5403 Southwest 41st, Pembroke Park, 33023. The deck, which was installed, was done over 8 years ago, along with myself and one of my family member. We did contact the city during that time and asked if we needed a permit for a free deck and was told no. Also, the management company at the time, we contacted the management company and we were told that we did not need a permit because it was a free deck and we could go ahead and install the free deck without, because it has no rail and it would only be a free deck.
Do you have that in writing?
I don't have that in writing,
Okay.
and that's, yes, yes. And the deck is not attached to the building. I have some pictures here, I don't know if.
Is it your understanding that, because again, I don't, I know the law, but I don't necessarily know all the technical building, that
I confirmed with the building manager of the permit of the canopy and the wooden deck.
The canopy is something that just, it's screwed on the deck. And the
Right.
deck, we reach out, we've been in contact with them for a couple while, and I asked to get a picture of because we got some contractors to come out and look at it, and they told us they couldn't give us a permit because it's not attached to the building.
We need an
And we need an
architectural
architectural,
drawing.
we contact an architect, they said they cannot do it, they wouldn't put their signature on it because it's not structurally down enough, it's like
They did not do it from the get-go, so they are not, they don't want to go ahead and do it.
And I asked, she was gonna take the pictures and bring it to the city manager to ask him if it was okay. I came back because I haven't heard from them since June about it, so I figured it was all done with. So
Right.
when I came back, because we got this
Wait a
letter.
minute, who are you?
I'm Jermaine, I'm the wife.
Okay, all right, I'm sorry, go ahead, yeah.
And I asked, I called her to ask her if, no, I came here. And then I asked for the pictures to show that the washing machine, it wasn't a washing machine, it was a dryer. Because it was in the time of COVID, we couldn't get anybody to remove it from the deck. It wasn't plugged in or anything. It was stored there because we bought a new machine and a dryer. And we were, gonna throw it away, but we couldn't throw it away. The dumps were closed. So I asked her if there's any way we could get, the pictures to show, because everybody's telling us they can't give us the permit because it's not attached to the building. So we didn't hear from them, so I thought everything was done, and we got the letter. Now I called her to ask her about it, and she said, I still need a permit to take off the gazebo, which is, I said, no, because it's screwed in, so I could just remove it, take something and remove it, because I didn't get a permit to put it up there. And the deck it's a free deck, it's not on the building. So I thought it was done with and over with, but now we get the letter said we have to.
Yes, I
I
spoke
don't
to
wanna
her
remove
prior
it.
to this hearing, and I told her to comply before the hearing. Now, as far as if she wants to keep the canopy, there's conditions. If she wants to keep the canopy, she has to obtain a permit, and that would be the permit for the canopy and the deck. If she wants to remove the canopy, the building manager confirmed she doesn't need a permit to remove the canopy. Now, if she's gonna remove the deck, she needs a permit to demolish the deck.
And how much a permit?
So what the building manager is saying is that if she's gonna demo the deck, she will include the canopy in that permit. So it's on record.
Because all right, so the bottom line is, and I understand what you're saying, and I think I heard you before, and and that there's been some miscommunications here, but bottom line for me is, I do listen to people, but you're a layperson, you're not a contractor, you're not a builder.
Yeah.
And I don't have a contractor here telling me you don't need a permit. The town is saying you need a permit to remove the deck or to demolish it, I should say, and you need a permit to remove the canopy, and if the canopy is going to stay, you need a permit for that. And that is per the code, right? I mean, there's no dispute about that. This freestanding thing that he was talking about now and he talked about last time, is there an exemption for some freestanding?
No. And that's why I checked with the building manager.
So I regret any miscommunication or misimpression, but apparently, and if you need her to repeat it, she will, these things need to be permitted. So,
and would we need a general contractor in order to get a permit to demolish?
The building department says you need a contractor. You can't do it. Yeah.
So I can't pull it down myself?
You would have to speak to the building official because he's the one who can override things. But my understanding is that when you're in an association, a place where there's an association, you always need a contractor. They don't allow homeowner permits.
We were misguided by the association from the Jump Street because we have it 8 years ago. And like I told you, we wouldn't put it up there if we didn't get authorization to put it up there. You understand?
Do you have something in writing from the association?
She didn't give us anything.
I can't.
I understand totally.
We understand that. That's okay.
I cannot rely on that. So what, I mean, I do remember this case now. What is the time frame again that you're?
My recommendation is to get it done within 30 days.
And you think that that's doable?
Yes, unless
No,
your circumstances.
I really don't want to tear it down because that's my husband's livelihood. I really don't. So I could
That's his
remove the
livelihood?
canopy, but I would love to get the. And like I told you, it's so hard to. And I get it. I get
I mean,
people from you guys.
what is
and
your
it's so
livelihood
hard.
that is tied into? What is it what is the commerce that is tied into that?
It's in Estancia Townhouse. It's a little townhouse, so we don't have any livelihood back there. That's the only thing we have there. So, we could go out and have a seat and.
Okay, so I misunderstood. I
love
thought you
to
said it
keep
was
it.
your husband's livelihood. And I was
Yes,
thinking-
because he likes to go out and grill back there and, sit and have a
But
good
that's not
time.
your life, that's just your
For now,
pastime, that's.
yeah, for now, because we can't go anywhere. So for right now, that's where we go to enjoy
Right,
ourselves.
right, but it's not a business.
No, it's not.
okay.
No.
When you said livelihood, okay.
So if you give us a little more time, then I could try to get somebody. Now you said we could get a contractor. I asked somebody to come out and look at it. Then we'll try to. I want to keep it. I don't want to tear it down and do the repairs with.
That
the
is my
permit.
understanding for the building department, that you need a contractor, but I urge you to speak to them directly.
Yes,
If the
you should go
building
see the
official
building.
gives you some leeway, then the merrier.
Okay, we'll go back there and ask him. But we want to keep it. We don't want to tear it down. So if you give us at least a
Right,
little
but are
more
you-
time,
I don't-
we'll
How much
repair
more
it.
time are you asking?
60 days would be fine.
Okay,
So
60
we'll get
days.
the permit and, like she said, repair it and keep it because I don't want to. And we'll get rid of the canopy. All right.
So based on the fact that, I mean, I have seen you before and I have esto está mal porque son dos
No, we did
copias
it
de la,
before.
no hay una segunda página.
Somebody else.
No, this is our first time coming.
You need one?
Bueno, it's just,
This is new one.
lo estás usando.
No, it's new one.
Okay, sí, pues, gracias. Order will provide that you have 60 days
Okay.
to comply. I would encourage you to go to see building now, or if not, to make a formal appointment with them. I remember this case. I think 60 days is generous in light of, this seems relatively straightforward to me. Again, I'm not but I would not entertain any further extensions on this, so you know,
That's fine.
all right?
That's okay.
And if you hang on a moment, and the $50 per diem after 60 days, right?
Yeah, 50 per diem.
So if you don't comply, and again, I do not myself plan to grant any further extensions, I'm just advising you, it'll be $50 a day until there's compliance after the 60th day. So I hope you comply within that 2-month period, fully comply. There's a $100 administrative fee that's charged for each case. Okay?
And the administrative fee, we would get a notice for the payment, or how does that work?
No,
Right, you received the final order today, and you will receive it in certified mail as well.
All right, not a problem.
Right.
Thank
And
you.
and then you have to pay that to the town.
Yes.
Okay, thank
So
you.
there's no confusion about that either, please. So please remain a minute, and you'll get a copy of this order. Thank you for coming in.
We're on page 4 of the agenda. 9.6, case 6066.
Okay?
Officer Teresa Malcolm for Town of Pembroke Park, Florida. Property site address is 4308 Southwest 41st Street in Pembroke Park, Florida, 33009, Building 4009, Unit 104. Property owners are Pembroke Villas Apartments LTD. Original notice of violation was. Sorry, my mic doesn't like me. Original notice of violation was written on July 27, 2021. Property was the notice of formal hearing with a copy of the notice of violation was posted to the property as well as certified mail on 9/28/2021. The notice of violation was for a roof leak in the master bedroom which needed repairs in the ceiling as well as the baseboard throughout the unit. Also, a water heater was replaced in the unit without a permit, which needs a permit for the after-the-fact installation of that 2018 unit, as well as a AC that was replaced without a permit, which requires a permit for the after-the-fact. My recommendation is to give them 60 days to comply with a per diem at $100.
Is there anything else at this time?
No.
Okay, please give your name, your address, and what you wish to say about this.
My name is Catalina Montano, and the property address is 4801 Southwest 41st Street, Pembroke Park, Florida 33023, and I'm the property manager. At this point, the roof was repaired, the base were repaired. The only thing we're missing are the permits for the water heater and the AC. So we will take the 60 days to get the permits.
The roof repair needs to be confirmed by the town and approved.
What do you need for proof? For the roof?
The actual roof of the association on
The
top,
leak,
or you
she
mean
lives on the
the
first floor.
ceiling?
No, she lives in the first floor.
Right.
And the leak was coming from the roof to the second floor to the first floor. No. No.
patch area.
Yeah.
It was a patching,
Mhm.
okay.
Yeah.
Oh, because you said roof repair, so that's
Because
why.
it was coming from the
Okay.
second floor to.
All right, well
the
then
first
that,
floor.
your record should be amended, so we don't have to hear that if it's clear to everyone that that part does not require a permit, then amend your record so we're not back here on that, because, all right, so then, is there anything else you want to say?
No.
All right, so the order to be entered on this will provide that you have 60 days to comply as to your outstanding matters for the water heater permit, AC. You have 60 days, and if not, it's a per diem of $100 per day. If you have not complied in 2 months or 60 days, and there is a standard $100 administrative fee, and that's what the order provides. And you can get a copy of it now if you want to wait a minute.
You also have another case on the agenda for Pembroke Villas.
Okay, so what case is that?
That's on page 3,
And what's the number?
8.2.
What is it again?
8.2, page 3.
Okay. Just for the record, and this is my observation, if we went in the actual order of the docket, we wouldn't have all these delays.
Right.
Just because we never do, I'm just
on
pointing
the
that-
list, she didn't mark that other case.
Right, but I don't know, I'm just saying.
Okay, Chief Code Enforcement Officer Jocelyn Ramirez, case 5202. Property owner Pembroke Villas Apartments LTD. Property address 4803 Southwest 41st Street, Pembroke Park, Florida. A notice violation was given on June 30, 2020, by hand and regular mail. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on August 31st, 2021, and posted to the property on October 3rd, 2021. The violations were for a damaged chain link fence, exterior maintenance of common areas, stairwells, light fixtures, directional signs, exterior maintenance of monument signs, exterior maintenance of roof required, exterior maintenance of walls required, overgrown vegetation, graffiti, and removal. There's dead vegetation that needs to be removed. An exterior fence wall adjacent to Condado Real, the condominium next door, requires maintenance. At this current time, the damaged chain link fence has been repaired with permits, and all the other violations are still outstanding.
And what is your recommendation?
My recommendation is to,
No.
for the property owner to comply within 60 days, if not $100 per diem with $100 admin fee.
Excuse me, Jocelyn, where is this case number?
5202.
I am very sorry, I was,
My recommendation is 60 days, if not $100 per diem with $100 admin fee.
Madam, would you just for the record repeat your name and tell me what you have to say about this?
Catalina Montano, and Jocelyn, I have a question. Where is the vegetation exactly?
Dead vegetation, and the overgrown vegetation
Where we
is in the
replace the fence?
front end of the property, which is obstructing the right-of-way. Can you show her the pictures so she
Show her
can
the
see?
pictures. Right?
There, show her the most recent pictures. I think is, so you see the roof has dirt built up.
That was fixed.
Yeah, I stated on the record. That's the monument sign, the graffiti on the column, sidewalks, has to be the common area, the wall adjacent to the condominium. There's overgrown vegetation there. Go a little slower, please. The common areas. There. You see how it's obstructing the sidewalk? All that has to be trimmed.
Okay.
And if anytime we can go over the pictures, you can call me.
Can you send them to me, to the email, please? Yeah, can we get 90 days instead of 60 days?
Is that a reasonable request?
Yes, they're extensive maintenance, and I think they have to go to chain of command to get this approved.
Okay, so I'm going to give, in this order, 90 days. If not, there's going to be a per diem of $100 per day, correct? And the $100 administrative fee. And again, as you heard, I don't want to hear any further extensions because I think these are, very reasonable periods of time. So please take care of it within that 3-month period. If you would, and if you want to remain a moment, you can get a copy of your orders.
Okay, thank you.
Thank you. But what else do we have?
Give me a moment, let me see the agenda.
Yes, that's fine.
Okay, page 3, section 8.7.
is number 6109.
Yes. Chief Code Enforcement Officer Jocelyn Ramirez, case 6109. Property owner Miami Station Split Co. Property address 3401 West Hollandale Beach Boulevard, Pembroke Park, Florida. A courtesy notice was sent out on March 24, 2021, and sent out by regular mail. A notice of violation was sent out by regular mail on July 30, 2021. A notice of formal hearing with a copy of the notice of violation was sent out on August 2021 by certified mail. However, the property owner requested a continuance. Therefore, a notice of formal hearing with a copy of the notice of violation was sent out by certified mail on September 30, 2021. Hang on a second. Yeah, September 30, 2021, and posted to the property on October 3rd, 2021. The violations were for exterior building requires maintenance, removal of dirt buildup, dead palm tree near parking lot entrance, and monument sign that requires maintenance. At this current time, a new palm tree has been planted, so that's been complied with, but as of today, the other violations are still outstanding. And my recommendation, after discussion with the gentleman right here, is 90 days to comply with the violations, if not $100 per diem with a $100 admin fee.
Is there anything else at this time?
No.
Sir, name, address, and tell us what you wish to say, please.
Howard Driller, property manager for WPLG, 3401 West Hollandale Beach Boulevard, Pembroke Park. We have, there's a lot of work going on in the building right now. I've hired an engineer and a contractor, and we have the drawings and everything ready to go. We will be submitting for permits to do some structural steel work, to pressure wash the entire building, paint the entire building, and seal the entire building. It's a tilt construction, 2-story building, and they require sealing about every 10 years or so, and we're in the process of doing all of that. It's somewhere around $450,000 worth of work, so it's just been taking me a long time to get set up and approved through my executives.
I think that looking at the photos, that it is apparent that exterior work needs to be done to the premises. 90 days, something that is doable, I think, but, do you have any?
I think that Pembroke Park's main concern is just the dirt buildup on the outside of the building, and it does, it looks bad. But the pressure washing will be done very soon, because that has to be done prior to painting, and we're very close to putting in for permits. I actually tried to get them to do it before this date, but I couldn't get it through my executive committee.
Okay, and I appreciate that, but again, that's not a problem that is related to the town. So that's an internal problem that you have to navigate.
Yeah.
All right, so the order is going to provide compliance for 90 days. That is 3 months. If not, there's going to be a daily fine of $100 starting on the 91st day. Hopefully you'll be in compliance, won't have to worry about that. And there is the $100 standard admin fee for the case. That's what the order provides, and if you want to remain a moment, you may get a copy of the order.
Okay.
Do you know when the monument sign will be taken care of?
The monument sign, that is there's a guy named Bill McCord that's handled that. He has a proposal he gave to me yesterday for everything to get done. The letters, we're actually replacing one of the signs. The main entrance sign is all staying the exact same, but just getting replaced for aesthetics. The delivery sign is getting changed completely because we get too many food deliveries coming into that area, so they're going to be adding a no food deliveries caption to that sign.
Okay.
So, but it's all happening. It's just a matter of, like I said, I don't know how long did permitting take for something like this? Do you know?
It shouldn't take long.
That's my only unknown is how long it's
Our
going to take
building
to pull the
department
permits.
moves pretty quickly, so as long as the contractors submit the work on time and they're on top of it, it should go smoothly.
It should be submitted next week. Capital is the name of the contractor, but like I said, my
Just-
executive
just
committee
keep
is my
on top
biggest
of them.
holdup. Oh yeah, I have been. It's my own executive committee that's been killing me.
Okay.
So thank you.
You're welcome.
Thank you. Thank you, sir, for coming in.
Okay. Now we will go in the order of the agenda, unless you want to take a break. But I know you had to leave.
Well, I'll take a break before we, no, I don't need to take a break. We can just proceed at this time. If I need to, I'll tell you. If not, we'll
Okay.
just go through but I'm presuming that these will be more expeditious because they're, there's no opposition.
Right.
Okay. We're on page 3, section 8.1, case 5143.
That's case 5143. And, okay, thank you. Yeah. Good.
Chief Code Enforcement Officer Jocelyn Ramirez, case 5143, property owner Ron B. Smith, property address 3911 Southwest 52nd Avenue, Pembroke Park, Florida, 33023. A notice of violation was given on June 18, 2020 by regular mail. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on September 30, 2021, and posted to the property on October 3rd, 2021. The violations were for AC replacement without a permit and exterior maintenance of wooden fence required. At this current time, the owner has maintenance the wooden fence, but still requires a permit for the AC. The owner explained to me that he is working on it. And so my recommendation is to give the owner 45 days to comply, if not a $50 per diem with a $100 admin fee.
Based on the unrebutted testimony, owner is not here, and all evidence accepted into the record without objection. Order will provide for 45 days compliance, and if not, a $50 per diem, and the uniform admin fee of $100 is provided for as well. So we have entered that order. All these orders where there's no respondents will need to be mailed to the respondents.
Right. Same page, 8.3, case 5276.
5276, okay.
Okay. Chief Code Enforcement Officer Jocelyn Ramirez, case 5276, property owner Anne Marie Prelux. Property address 209 West Lake Drive, Pembroke Park, Florida. A notice of violation was given on July 22nd, 2020 by regular mail. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on September 30, 2021 and posted to the property on October 3rd, 2021. I'm sorry, October 4th, 2021. The violations were for an installation of wooden deck and a roof over without permits. At this current time, the owner has not obtained a permit. Therefore, I'm recommending 45 days, if not a $50 per diem with a $100 admin fee.
Based on the unrebutted testimony, the order in this matter will provide for compliance within 45 days. If not, there will be a $50 per diem, and the standard $100 administrative fee is hereby imposed. And again, as with all these cases, so I don't have to restate it, all evidence in the record is admitted. Thank you.
Next would be on page 5, section 12.4.
That's case number 4900, Ano or Ano LLC. Okay, thank you.
Okay. Chief Code Enforcement Officer Jocelyn Ramirez. I'm presenting this case for former Code Officer Jeffrey Lewis. Case number 4900, property owner ANO LLC, F9 Properties LLC, tenant Cabinets to Go. Property address 1960 Southwest 30th Avenue, Unit B, Pembroke Park, Florida. This matter is here today for a confirmation of fine. The notice of violation was given on July 31st, 2020 for having a portable shipping container in front of the business and for using the portable container as a signage, as a permanent sign. The property owner came into compliance as of October 12th, 2021. Okay, I'm sorry, October 13, 2021.
October 13th, 2021.
Yeah. The fine accrued from May 13, 21 to October 13, 21 for a total of 153 days at a per diem of $50. The total accrued to $7,650. In addition, a $100 administration fee. The total confirmation of fine is $7,750.
Based on the unrebutted testimony and all the evidence of record, a supplemental order certifying the code enforcement lien is entered for $7,750. That's inclusive of the $100 admin fee.
What happened? ¿Qué pasó?
Notarizing.
Notarize. Okay. I need Teresa to come and notarize it. So we'll just let her
Right,
know.
and again, there's no need to have those orders.
Notarize? Okay. I'll have to discuss it with the other magistrate. Because he's the one who actually entered them like that. He provided us templates, and that's one of the templates he provided.
Right, it's not a federal case to me. I mean, it's you know, if, based on something that makes him more comfortable. What is important is that if you're going to record orders to impose liens, it needs to have the folio number.
Okay. All right. I'll mention that.
That's per state statute, and I can give you the statute, but it's, there's a Florida statute, so if you're,
Yeah, if you know the statute, that'd be helpful.
yes, I mean, I don't have it right, but I can.
No, yeah, later
Yeah,
on.
Yes, I'll give it to you later on. I'll forward it to you. That's important, but the,
I know you forwarded me something saying that the folio number is important. You already forwarded me, so maybe you put the statute in
that
there.
is, yeah, it is in the statute is there. It should be like 693. Look, and if that's not it, why don't you tell me, and then I'll send it to you.
Okay,
That-
yeah.
But yeah, I think I sent it to you now that I think about
Yeah,
it.
you sent me something about it. I read that the folio number, and I replied that, yes, all the folio numbers are in there.
So again, to me, this is not, I mean, it's actually, it's a task for the town, not for me. I simply sign them if they're correct.
Okay, so the next case
Yes,
is
is-
on page 6,
Yes,
12.5.
right?
However, I was recommended by the attorney that I hear section 14.1 first, prior to this case.
So we're going to hear 14.1 first.
Yes.
which
Prior
is
to the
case number 5006,
Yes.
5006.
prior to the confirmation of fine.
All right. Let the record reflect that nobody else is present here, so, other than the town personnel.
Okay.
Go ahead. Return for the notarization, by the way.
Chief, yeah, we need it. Chief Code Enforcement Officer Jocelyn Ramirez, case 5006, property owner Cole FD Portfolio 3 LLC, care of Family Dollar 26608, property address 4100 West Hallandale Beach Boulevard, Pembroke Park, Florida. Today, this matter is for the town's motion to amend the final order that was entered on April 13, 2021. And as always, I'm presenting this case on behalf of the former code officer Jeffrey Lewis. The reason for the amendment of the final order is to reflect what was said at the hearing on April 13, 2021. Former Jeffrey Lewis, Code Officer Jeffrey Lewis, stated that he would like to accrue the fine from the compliance date given on March 6, 2020. So the order that was entered did not reflect that.
Okay. And we're correcting that.
Yes, we're correcting it so it reflects what he stated on the hearing on April 13, 2021. I have a copy of the previous order if you'd like to see it.
Yes, is it in the record? The record?
Yes.
There, okay. Earlier order of April 2021 is administratively noticed. That's what you wish to correct.
Correct.
Correct. That's correct. Okay. All right. So I'm going to enter first the order per the town's request and the evidence and testimony on file, including the prior order. I'm going to enter now the amended final order, which I have entered at the request of the town. And now you have another component to this, which is the supplemental order certifying the code enforcement lien. What do you want to say about that?
That's for confirmation of fine.
So this provides for the fine to be confirmed at
$50,000.
correct amount for the time period computed, right?
Correct. So I'd like to state for the record that
Yes, that's why it was, yes, go ahead.
for case 5006, property address 4100 West Hallandale Beach Boulevard, we're confirming a fine of $50,000. The fine accrued for, here it is, for a total of 583 days from March 16, 20 to October 2021. The property is still not in full compliance. It's at a per diem of $100, which total $58,300. It was the town's commission to cancel the daily fines due to COVID-19 for the period of March 18, 20 to June 10, 20, 84 days, which reduces the amount of to $8,400. In addition, a $100 admin fee, which totals $50,000.
Okay, based on the unrebutted testimony from the Chief Code Compliance Officer and the evidence on file, including the earlier order, which has been amended and was administratively noticed, I've entered an order, supplemental order certifying code enforcement lien. This one provides for notarization.
Next is section 15.1.
$15.1.
Yes. Chief Code Enforcement Officer Jocelyn Ramirez, case 4949, property owner Condado Real Condominium Association, Inc., property address 5100 Southwest 41st Street, Pembroke Park, Florida, 33023. This matter is here today for an amendment of the order, the abatement order.
Yes.
The reason for this amendment is because at the time of the July hearing on the 20th, 2021. We abated the fine to $850 and gave the manager 60 days to pay that fee. However, during that time, there was a transition in management. And so the change of management caused information to be missed, and the new manager was not aware of this abatement. So,
The town is satisfied that the new manager was entirely unaware of this.
right. Once the manager came into our office asking about any outstanding fines or violations, he was able to let us know that he's more than willing to pay this fine right away. He just would like the same abatement, $850. So I am bringing it to an amendment to give the new manager 30 days to pay this fine.
Okay. Per the request of the town, I am going to provide for a 30-day period for that to be paid, $850. It being the request of the new owner and the new owner being aware of it, and it being discussed with the new owner, correct?
Correct.
There shouldn't be any reason to amend this order further,
Correct.
all right? The order so entered.
Thank you. Okay, next is on page 7, section 16.1.
Okay?
Okay. Case 6186, property owner Jeanette Verster, property address 2503 John P. Lyons Lane, Pembroke Park. This matter is here today to vacate the final order entered on September 15, 2021. The reason for my request is because they sent out a request for rehearing and reconsideration, and they have an exhibit here that the United States Postal Service didn't send the notice of hearing for September 15 in time for them to respond. They sent it it was sent out August 31st, 2021 by certified mail, and they didn't receive it till September 7th, 2021. So I am considering considering the request, and therefore I would like to vacate the order and continue it for next hearing.
Based on the request of the town and the testimony of the town and the evidence that the town has given, I am entering an order of vacating and continuing this case without prejudice to the town until the next hearing is held and scheduled.
November 17,
As
2021.
provided here is November 17th. So be advised that that's on November 17th, and I'm sure even though you may not be required to avoid any other snafus, the town will send a notice of that date of November 17th.
Yes, it already has been said.
It has been sent.
Mhm.
So there's no dispute about that.
Right.
Well, I've entered the order requested.
Thank you. And that concludes my cases.
Okay, at this point, I will,
The break?
very brief break. But don't, I mean.
Mary, we're taking a break.
Yeah, it's very brief. like 5 minutes or something, okay, that's it, I mean. I see your point, go ahead.
Okay, we're ready.
Code Officer Teresa Malcolm for Town of Pembroke Park. I'll be presenting the next few cases. Case 5710, case 6063, case 6065, case 6123, case 6126, case 6130.
Let's just take them each as they go. Let's go, please. Start with the first,
Okay, sorry.
okay?
Sure. Case 5710. Property address is at 2412 Sherry Lane, Pembroke Park, Florida 33009. Property owner is Real Marrier. Notice of violation was originally written on March 30th, 2021. Notice of formal hearing with a copy of notice of violation was certified mail on 9/28/21, posted to the property on October 1st, 2021. Notice of violation were for the following items: an addition that was built without permits, the prohibited shed on the property, which needs to be removed from the property, multiple doors that were changed out without a permit, stairs that were installed without a permit at the front door and the second door in the enclosure, as well as the back side of the house. The mobile home appeared to be divided into 2 units with a separation wall built in between the enclosed screen area. There was a possible renovation since there were bathroom sink on the floor, which requires a permit for plumbing. Railing that was installed at the main entrance door without a permit, and also to remove the hurricane shutter from the back side of the mobile home. I've met with Mr. Marrier back in April. We had a discussion. He said that they haven't did any renovations as of yet. They were proposing to go ahead and do some renovations on the property. So that's why, from my original interaction on March 30th, the sink and other plumbing equipment were on the floor. At this time, the only things that have been complied with, are still pending with the building department, were the stairs that were, a permit was issued for it. So everything else needs to be satisfied. So my recommendation for this one would be for 90 days with a per diem of $50 after that.
Okay, based on the evidence which is in the record, all admitted, and based on the unrebutted testimony of Code Compliance Officer Malcolm, there's going to be order entered now for 90 days compliance. If not, there will be a 50-day per diem or daily fine thereafter. And of course, the standard admin fee of $100 is hereby imposed, and that's what the final order Real Marrier case will provide, or Marrier.
Case 9.4, case 6063. Property site address is 212 Lone Pine Lane in Pembroke Park, Florida 33009. Property owner is Diana Rivera. Notice of violation was posted to the property as well, sent by regular mail on July 27, 2021. Notice of formal hearing with a copy of notice of violation was certified mail on 9/28/2021, posted to the property on 10/1/2021. Original notice of violation for repeat, referring to case 2267, or for a new addition that was built without permits, including electrical, windows, doors, and the roof over. The new wooden pergola or gazebo with benches that were built and added without permits, 2 AC units that were installed without permits, a camera system that was installed without permit, as well as to remove all the prohibited outside stored items on the property. At this time, to my knowledge, I actually met with the property owner in August.
What transpired?
Well, they asked us to go ahead. They asked us if, well, it was her boyfriend that came in to meet with myself as well as Jeffrey in the building department, and he just came to gather information and pick up the permit paperwork, and wanted to know if he could submit everything on behalf of her, which we told him that he can submit it for her, but she has to be the one to sign and have everything notarized on behalf of her. So from that, I haven't had any updates for them submitting anything. So my
There were no submittals after.
No.
Okay.
So my recommendation would be 90 days with a $50 per diem.
Okay. Based on Officer Malcolm's unrebutted testimony and the evidence all admitted in the record, the order entered in the Diana Rivera matter will be compliance within 90 days. If not, a $50 per diem or per day fine, along with the standard stipulated administrative fee of $100. Is so ordered. Thank you.
9.5, case 6065. Property site address is 3140 West Hallandale Beach Boulevard, Pembroke Park, Florida. Sorry. Property owner is Holiday Hallandale. Holiday Hallandale MCH LLC. No, original notice of violation was written on July 27, 2021. Notice of formal hearing with a copy of the notice of violation was certified mail on 9/17/2021, posted to the property on October 1st, 2021.
I'm sorry, but I'm always just a stickler for, you said MCH, but the order says MHC. I just want to be sure it's correctly.
I'm sorry, it is MHC.
Okay, no,
I'm just like,
it's
I'm
just
sorry, I read it wrong.
Don't worry about it. Go ahead. I just.
Original notice of violation were for the following items. Property has a lot of overgrown vegetation in multiple areas, to trim or cut vegetation and maintain it. Multiple broken parking curbs or stumps needed repairs. Parking lots and streets have multiple pothole cracks and is in dire need of repairs. They need to obtain a permit for parking lot repaving and restriping. Property has multiple areas where trash and debris are left over, to remove the bulk trash and debris from the property alongside the property line. Property has feather signs, snipe signs, banner signs, which are all prohibited, to remove all the feather signs, all those signs. Property has multiple slabs and sidewalks, which needs repairs with a permit for concrete restoration. The laundry room at 5th Street has a new water heater that was replaced without permit, which needs a permit, after the fact permit for it. The laundry room at 5th Street has roof damages, which needs repair. Multiple areas in the property line are missing sod, to replace the sod as needed throughout the property line and maintain it. Multiple broken tree stumps which have been trimmed, which needs to be trimmed to prevent further damages from the RVs and the mobile home, especially during the rainy seasons, which we have a lot of pictures to deflect the violation, which have been left, which the trees were falling and they just have been left abandoned on the property, which need to be removed as well. Miscellaneous loose wires, pipes are left abandoned on the property, to remove those. The carport is damaged at the garage area, which needs repairs with a permit. A water heater was installed in the laundry room by the garage without a permit. They need an after the fact permit for that. There is a roof inside the laundry room by the garage that also need repairs with a permit. Broken stop sign at 2nd Street, which fell and needed to be repaired and reinstalled. broken lamp posts on the lamps which needed repairs throughout the property line. Also, a chain link fence on West Hallandale Beach Boulevard needs repair. Since it is an extensive amount of
Yes.
violations, my recommendation would be 120 days. Keeping in mind that this is a repeat violation referring to case 4831.
Okay, administrative notice is taken of case 4831.
With a $250 per diem.
I think that is fine. Again, administrative notice is taken of the other case with constituting this as a repeat violation. It is so found, and you're recommending 90 days here, you said?
120.
120,
to give them
okay.
ample time.
Very generous. 20 days, if not, a $250 per diem, and the $100 stipulated administrative fee is hereby imposed.
I'm
Yeah.
sorry.
Sorry, were you saying something?
No, I was going to continue. Go ahead.
What, I mean, I've entered
I
the
meant-
order in this case.
Yeah, no,
So-
I meant I was gonna go to the next case.
Oh,
That's what I
yes,
was going to
yes,
say. I'm
please,
sorry.
continue, yes.
9.7, case 6123.
Go ahead.
Property site address is 4900 Southwest 36th Court in Pembroke Park, Florida, 33023. Property owner is Isaac Levy. Original notice of violation was posted to the property and sent by regular mail on August 4th, 2021. Notice of formal hearing with a copy of the notice of violation was mailed on 9/28/2021, posted to the property on October 1st, 2021. Original notice of violation was for 2 AC mini splits that were installed without a permit, as well as the house needed to be painted where the paint has been chipped away. At this time yesterday at 2:35 p.m., I received a phone call from the tenant there, since this property is being rented out. And I also have another address which the notice was sent over in New York too. And this email says, "Hi Teresa, I continue our phone call from today. I want to let you know that I am Hemi Seprai. I am managing the property at 4900 Southwest 36th Court, and the owner, Mr. Isaac Levy, is aware of the violation and that the paint issue was taken care of. We are asking for 60 days of an extension to comply with the AC violation, since an engineer and AC contractor are involved with pulling the permits. The owner lives in New York City, and I have a personal emergency that holds me from being unable to appear. Thank you very much for your consideration," with his name and phone number. My recommendation would be for 60 days at $50 per diem, since it is only now to get the AC permits for the 2 mini splits, and I think it's ample time to go ahead and do so.
Right, based on Officer Malcolm, on your unrebutted testimony and on the evidence of record, I'm going to enter an order providing for 60 days compliance or cure period, and if not, a $50 per diem with the stipulated admin fine of $100. And the order is so rendered in this case, and lo que estaba oyendo, esa era tu computadora.
Es aquí abajo que hay como un problema en la electricidad.
No, es que estaba oyendo una cosa extraña y
De vez en
estaba
cuando
pensando.
parece que va a
Yo dije,
explotar.
no es mi teléfono porque yo lo apagué, porque lo apago. Era una cosa, ok, está bien.
9.7.
Excuse me, I'm sorry.
I'm sorry, 9.8. Case 6126. Property site address is 3610 Southwest 48th Avenue in Pembroke Park, Florida, 33023. This is for property owner Lake Forest Baptist Church, Inc. Original notice of violation was written on 8/4/2021 by regular mail. Notice of formal hearing with a copy of the notice of violation was certified mail on 9/28, posted to the property on October 1st, 2021.
Okay.
Original notice of violations were for the 2 prohibited banner signs on the fence, which there was no permits on file, but they needed to obtain a permit for the banners, as well as the parking lot is faded and has a pothole. They needed to obtain a permit for restriping and paving of the parking lot area. At this time, from my reinspection on October 1st, 2021, the 2 banner signs were removed, which I spoke with the owners this morning briefly about the current violations and explained that even though the signs were removed, they needed to have a permit for it. So she understands that. Also, she says that she also sent the text over to. Okay, so she sent the contractor that they hired sent the message over to Jocelyn this morning, and it says, "Hello, Jocelyn. This is Roger from Point of Grace. I was not able to attend today because of an emergency situation. We are under a contract with Arrow Paving to get the work done. We are going to need an extension to get the work done because some things got messed up in paperwork and we ran out of time. 2 of the 3 violations have been corrected. Please call me back if you have any questions. Thank you very much." Also, they shared with us basically like a contract that they just entered in with Arrow Asphalt and Engineering, Inc.
They gave you a copy of that? They
It
emailed
was
a copy?
It's a text message.
With the contract included?
I don't have the contract included. I just have the receipt that they made payment to enter into it.
Something, I guess.
Something, right. I also made a brief phone call to confirm because they mentioned Point of Grace, but for me it was Lake Forest Baptist Church. So I just wanted to confirm that it was the same case. So I spoke with the contractor. I spoke with Rebecca Langston, which she says she's the treasurer for the church. She understands that she needs to obtain permits. And after this hearing, I'm going to give her another phone call so we can continue that conversation. So she is aware of it. My recommendation would be for 90 days, thank you, with a $50 per diem.
Based on Officer Malcolm's testimony and the evidence of record, all of which is admitted and unrebutted, I'm going to give them 90 days for compliance. And if not, there will be a $50 per diem. And of course, $100 administrative. That is what the order is going to provide, and you establish that this is Lake Forest Baptist Church, Inc.
Correct.
Okay.
9.9, case 6130. Property site address is 3140 West Hallandale Beach Boulevard, Pembroke Park, Florida, 33009, lot 903. Property owner is Bertilda Archinold. Notice of violation was written and posted to the property on August 6, 2021. Notice of formal hearing with a copy of the notice of violation was certified mail on 9/28, posted to the property on 10/1/2021. The original notice of violation was for multiple additions added to the mobile home without permits, including electrical and plumbing. They need to obtain a permit for those after the fact. Also, the additions had French doors, as well as French windows and multiple exterior windows, as well as a stair that was added without permits. A water heater was replaced without permit. They need to obtain an after-the-fact permit for that water heater. Also, the patio area, it needs to be permitted, including the rails and the concrete stairs with permits. Vinyl siding was added to the multiple additions without permits. They need to obtain an after-the-fact permit for it. Also, excessive prohibited outdoor stored items were on the patio area throughout the property line, which needed to be removed as well as cleaned up, leaving only the patio or lawn furniture. Also, to schedule an inspection with the code enforcement officer to verify the number of occupancy in the home, since only one family is allowed to reside in the home. At this time, for my reinspection on October 1st, 2021, I went to post on the property and to do reinspection pictures, and there's pictures to depict that. In the records, the property owners went ahead and actually removed the AC that was originally on the property, and they had the new AC on the side. So I then went ahead and had to issue another notice of violation on that property, which that repeat violation is going to be for case 6429 for future.
Okay. Administrative notice is taken of case 6429, which is deemed as being, included in the findings of fact and conclusions of law for this, per the record.
Also, I received a phone call from Miss Angelica Archibald in regards to the case and the court hearing, and it says, attention, Teresa Malcolm, the following is to notify you that I will not be able to assist with the hearing scheduled for 10/20/2021 due to health issues in my household. We are trying to overcome a flu or COVID-19 virus. Is not confirmed with my doctor yet. Such symptoms seemed like COVID-19 when I had a video med appointment. This virus has persisted for now 20 days. Hoping we will recover soon, I would like to request some more time to cure and comply with the violations. Thank you. Thanks in advance for your understanding. Sincerely, Mrs. Bertilda and Angelica Archibald. So that being
But
said,
her legal name, again, we're satisfied that it's Bertilda Archinold.
sorry, Archibald, I'm not sure. I got that information originally from the property management company, so that may be a typo on their end.
But, it's important in the order.
Right.
Things like the folio address, is the name of the person that we have on this order, Bertilda Archinold.
Or Archibald, correct. That's something that I'll go out and verify with the property manager, because the only thing I have was a text message.
Because you don't have a record with her name.
Correct. I don't have access to whatever tenant list that they have. They only, when we call, they just give us that information, and I actually have a text message from the property manager, and it's spelled Archinold. So that's something that I'll have to go back and verify.
I guess what, maybe just for my edification, or maybe I'm slow as molasses today, what I'm trying to, she is the owner, isn't she?
This is a mobile home park.
So with the mobile home park, there is no way for you to verify. No, that's the interesting technical point to me.
The only thing I can show it to you. The only thing is I have, like I say, a text message when I reached out originally to
Right, no, but I'm not being clear. I'm asking a question. Because I want to know this. With a mobile home, that the owner owns a mobile home, and the recreational district or mobile home park owns the underlying land.
Correct.
On the property appraiser site.
Correct.
There is no way, per the mobile home,
That I can identify the
that can
actual
identify
park.
the.
Correct. Yes.
Okay, I had to know this. I understand. Archinold. It's usually Archibald, but I don't know. You might,
So that may be a typo on them.
Bertilda.
Has an email here.
How is it spelled there?
With a B instead of a B.
Yes, yes. I'm going to tell you that the order which appears on the first page, you should put, you don't have to do it right now. You can do it, it's clerical, you can do that later. I'm telling you. Put Bertilda Archinold, also known as,
Okay.
you know?
Archibald.
Archibald, right.
Okay. I will get that corrected prior to us leaving today.
Again, you don't need to, that's clerical. That's like saying, you just do that, you're not changing anything in the order. It's just, you can do it now if you want, but I'm just,
I'll
so
do it
you're,
prior
you're,
of us leaving
all right,
today, so we could just
because,
enter the-
all right. So what was your recommendation on this?
It was 90 days with a $50 per diem.
So,
It's her daughter,
the order entered here, taking into account the prior case which was noticed, is going to be 90 days for compliance or cure with a $50 per diem plus a $100 admin fee. Which you want to correct, which is fine. I mean, I'm just saying that when that's
It'll be
what's
really quickly.
like a
We'll-
Scrivener's kind of thing, that you could just,
I'll get it to you prior of us leaving today. It's just that the laptop is in there, so I just want to finish
Yes,
the
that's-
cases.
yes,
and
yes,
then-
you can, yes.
Okay. All right, 9.10, case 6147.
Okay,
Property site address is 4790 West Hollandale Beach Boulevard, Pembroke Park, Florida, 33023. Property owner is Hanlex Properties LLC. Original notice of violation was issued on August 13, 2021. Notice of formal hearing with a copy of notice of violation was certified mail on September 17, 2021, posted to the property on October 1st, 2021. Original notice of violation were for the following items. Building needs to be pressure washed and also the property wall at the back end was tagged twice with graffiti to remove the graffiti and paint the wall. The property has a lot of debris and trash left over in the swale alongside the property, which needed to be cleaned and maintained regularly. At this time, from posting to the property, the trash was still there. I actually drove by on Friday, 10/15, 2021, around 4:50 p.m., and all of the trash was removed. On the other hand, the pressure washing of the building is still there, so it's still a valid violation. Also, the graffiti has been removed from the wall. So, keeping in mind, this was a repeat violation, referring to case 4766.
4766 is administratively noted and included that finding a fact that this is a repeat violation. Go ahead.
My recommendation is to give them 30 days to pressure wash the building with a $200 per diem after that.
Did you say 200 or 250?
Yes, 200.
Okay. The order, based on the unrebutted testimony and the evidence in record, will be that there must be compliance or cure within 30 days. If not, there will be a $200 per diem. And also administrative notice taken of the prior order is read into the record. And it is so ordered in this case involving Hanlex Properties LLC.
.11, case 6155. Property address is 2503 Don P. Lyons Lane in Pembroke Park, Florida, 33009. Property owner is Jeanette Verster. Notice of violation was written on August 23rd, 2021, Notice of formal hearing with a copy of the notice of violation was certified mail on 9/28, posted to the property on October 1st, 2021, for the following items: to remove excess crates, wood, and trash from the property. Fine Foods, which is a tenant of the property, has a faded and rusted sign, which needs to be refreshed. The building walls on that particular unit needs to be pressure washed and painted. To trim the trees on the alongside the property line. Parking lot is completely faded with cracks, and some parking stumps need repairs. And also to remove a wooden structure with strings that has a sign that says no parking in the parking lot area. They need to obtain a permit for parking lot restriping and repaving. Marine Top Shop.
The parking lot does need to be restriped and repaved.
Yes.
Wooden structure.
Right, yeah. That's a part of the string that they have this designated area that says no parking with.
What looks like a clothesline.
Yeah, or something of that. They're a bit creative. Marine Top Shop in Unit A has a new banner with no permit on file. They need to obtain a permit for that banner sign. Marine Top Shop in Unit A has a racking that was installed without permits. Need to obtain a permit for those racking systems. Marine Top Shop is occupying the unit with no current business tax receipt for this location. They need to obtain a business tax receipt within 3 days from this notice. Top Shop in Unit A has different machinery equipment installed without permits. They need to obtain a permit for the machinery that's installed. Marine Top Shop in Unit A needed to schedule a walkthrough with code enforcement to verify the bathroom installed as well as the extra storage in this unit. If not permitted, then a permit needs to be obtained for those items. Also, the property itself had cameras that were installed without a permit, as well as the rusted boulders that needed to be painted. At this time, I went out and received a phone call from the tenants in Marine Top Shops in Unit A of the property. I went out to do reinspection pictures on 10/12. To my findings, which the pictures are to the records to depict what I found.
Yeah, as I said earlier, all evidence that is not objected to goes into the record, is made part of the record.
Okay, so I went ahead and do due diligence with the building department to find out if there was any alteration permits for that unit, as well as racking, electrical, and the banner, as well as the bathroom. So
And-
far, there is nothing obtained on it. What we found was, since my reinspection or walkthrough from
And
the
when you
tenants.
say nothing obtained, means that building produced no record of permits? Is that what
Records
you're
of
telling me?
those.
Okay, all right.
That actual space was actually subdivided without permit. So they now understand that there was another issue, there was
But
another
that violation is not before us here.
No, but
We're
I
not
was just
gonna,
speaking
we're
into
not
the
gonna, right,
records.
we're not,
Okay, so just to clarify, this is a second offense, referring to case 6186.
Case 6186 is administratively noticed and is deemed as being incorporated by reference into the record as to this being a repeat violation. Go ahead.
My recommendation would give the owners 120 days to comply with a per diem of $250 after that.
Very generous, 120 days is.
Right, since it's extensive and now we
I
find
mean,
out
that's literally 6 months almost, or 5 months, but, okay. But you think that's reasonable under the circumstances?
Right,
Okay.
right.
120 days is afforded for compliance. After that, as a repeat violator, there will be a $250 per diem based on the unrebutted testimony and the evidence on file, all accepted. The finding that this was a repeat violation is stated, and the $100 administrative fee. That's hereby entered in this order. Este es el último. Ella quiere corregir el otro.
Mr. Magistrate, hearing this case, I noticed that she put marine shop, what was it? Marine top shop?
But the case is against,
Right, but there's multiple tenants here that might be liable for those violations as well. Shouldn't they be on the order as well?
well, I will tell you this, as a matter, that's a good question, and maybe we would want to reconsider this now, but you cannot jurisdictionally or in due process, in my view, add people that were not cited
No, I agree.
for an order. So you can't do that.
I agree.
So, but the basic rule is that the owner is responsible.
Yes.
So the owner is responsible for everything done by the tenants. Now, if the town, to be very informative or very impartial, wants to also notify tenants and make them aware or tell them, but I don't think that when if you notice the owner, they're supposed to tell the tenant, and the tenant should come in. But I don't believe that unless there's something in the code written differently here that would make a tenant responsible. But if you wanted to have tenants additionally bound by an order or something like that, which I haven't, again, the orthodox or traditional response is the owner is responsible
Right.
for what a tenant does. You would have to cite and notice them. So that what I can tell you 100% is they cannot be added like now.
No, agree.
Right?
Yeah. I'm just asking what is the best way to do it for future outcomes?
Well, I think the best way to do it for future outcomes, again, if it's not one of these, particular like homeowner associations where, you have the homeowners association or the HOA responsible for the common area and the clubhouse and the pool, and then you have the unit owners for each individual unit. So like I know if you were citing a condo, if it's an interior violation, you're citing the condo owner. If it's anything in the common elements, you're citing the condo association. If it's both things, you're citing the owner and the condo association. With this, I would say you have to cite the owner, and perhaps you should be doing, without obligating yourself, courtesy notices, or at least CCing the tenants. But I can't think of, again, speak to town council and so forth, but I can't, other than an owner making a tenant come in and come into compliance, the ultimate responsibility for the code enforcement is the owner. So, but what I can tell you is you can't add people that have not been, my 2 cents.
Nine point 12 on the agenda, case 6178.
Yes, go ahead.
Property site address is 2950 Southwest 32nd Avenue in Pembroke Park, Florida, 33023. Property owner is Garden Property 786 Inc. Notice of violation was written on August 25th, 2021. Notice of formal hearing with a copy of the notice of violation was certified mail on 9/28 and posted on the property on October 1st, 2021. For the following violations: abandoned vehicles on property, to remove all abandoned vehicles from the property, as well as remove all overgrown weeds on the property. Also, the chain link fence at the back needed repairs. Referring to case 4985, so this is second offense.
4985 is administratively noticed and deemed as part of the record in terms of this being a repeat violation. Go ahead.
My recommendation would be 30 days or with a $250 per diem after that.
Based on the unrebutted testimony and the evidence in the record, including the finding from the prior case, which is deemed incorporated, This is a repeat violation. There will be compliance within 30 days. If not, there will be a $250 per diem and $100 administrative fee is also hereby imposed. And is there any other
No, that concludes my case.
business to come before the magistrate? Is there anything else? As for, no, I forgot it. Anyway, you know, if you want to correct that order now
I will, yes.
and have me sign it, I will remain
Yes,
a
I
few
will.
minutes and sign it. But all you need to do is,
Add the name, it'll be
is
really.
you're right, you just need to put also known as A/K/A/A, you know, Helena, Kalk, whatever it was, you know, and Bettina, whatever. And, okay, and then I'll just remain a moment. And you know what? I guess at this point, and I did earlier, but just for the record, for all these modifications of orders, I do believe I did this before, but just to be sure, Section 7.7 of the code, powers and duties of the board and the special magistrate are administratively noticed for the conduct of these hearings in terms of the modification of the orders. And that's pretty much what I have. So is there anything else?
Not at this time.
So, 1:55 will stand adjourned. I will remain a few minutes to sign the order that you want. Thank you. Thank you all so much. Thank you all for your help and for your assistance today. And you can go off the record now.